similar matters was disposed, my lordships, and this was untagged here, tagged in the Supreme Court and untagged here, my lordships. Kindly give any specific date. This is the compensation was not given to the petitioner.
This is a final hearing matter.
Yes, my lordships. The Supreme Court matters, my lordships, and common orders was passed in 4th September 2023.
Some connected appeal has been decided.
Yes, my lordships.
Huh?
Yes, this is the connected matters.
No. Some ask her whether it has been decided.
Whether it has been decided by the Supreme Court.
No,
the
my
Monday.
lordships. This was decided in not decided in Supreme Court, my lordships. This was tagged here.
Monday. But
Supreme Court remand matter
decided that she is not clear.
No, any connected matter has been decided.
Yes.
Similar
in
order.
High Court.
Give the numbers.
You have the copy of that order, right, madam?
I don't have copy, but I have the writ petition numbers, my lordships.
You want a similar order, right? And you don't have the copy. No, are we correct in understanding that a similar writ petition has already been decided by this court?
My lordships.
Right?
In September.
You want a similar order, right?
Yes, my lordships. Yes.
Day after. Or let it be on this thing. 6th November.
Obliged.
Next Monday.
Let's say
Yeah.
entry tax matters are distributed between court number 1 and court number 2, Millard. Where the violence of the act is questioned, they are before this honorable court. And other than other cases are before court number 2. Court number 2 wants to proceed with those cases. We feel it would be better if it is heard by the same bench, Millard, first disposing of the constitutionality issue.
No, correct. No, that's correct. But he has to make a request, right? Like, please make a request in an appropriate form, like not orally.
Please.
Right? Please make a mention memo or whatever you for tagging, etc. It will be placed before us on administrative side. We will.
Okay.
Subsequent to filing of the consent order, order has been applied.
Learned counsel for the petition.
This writ petition is filed local. This writ petition is filed.
They have neither been heard nor notice. Learned counsel for the learned counsel for the petitioner submits that neither any notice nor any
May I please? Sir, their representation was given to the Mineral Election Commission. But with regard to the objection, enrollment of voter by the 8th respondent. But after filing writ petition, now the Election Commissioner issued instruction to the respondent number 3 and.
So what? You don't want to prosecute?
Lakshman recall this, I closed
Why?
Only consider my representation.
No. This can't be done. What is, you have not given Mr. details. When was the provisional list published? When did you file an objection? What happened to that objection?
She was not filed application. She has not filed any application.
Then this order, if inclusion of her name in voters list provides for an appeal under Rule 23, how a writ petition would lie?
Only consideration of my representation. That's what.
That's not, you are a statutory.
13 says, I can file an objection. Suppose any person file Form 6.
No, so you tell you in this petition, Mr. lacks in material particulars in this sense.
You last time close the writ petition in view of this.
In view of subsequent events which have
Include by the second respondent, my lord.
in view of subsequent events which have taken place after
I appear for the petitioner in this matter, my lord. On the last occasion, your lordships were pleased to order for carrying out publication in the Times of India, Chennai and Hyderabad editions, my lord. We have taken out publication in the newspapers, my lord, and both newspapers have been filed. I appear for
you appear. All right. So,
It has to be heard, my friend is saying.
ready?
so, my lord, senior counsel, Mr. A. Venkatesh, is appearing in this matter, my lord.
Uh,
So, like, any date may be given.
you are appearing for
I appear for the respondent. I am ready.
Both the respondents.
Mr.
Both the respondent.
Mr. Sharad Sanghi Learned.
It's an item number 5 and 6. We are informed by the respondents that they are filing counter today.
But we are in the process, send the counter for signature, the
Yes.
process of filing it today or partly tomorrow,
Lordship, kindly take up this matter next week, my lords.
or the week after that, I leave it to you, Marshal.
Week after that.
My lords,
All right.
the period of 6 months is ending on November 10th, my lords. Before that, on any date, my lords.
Yes. Why not?
6
Which
weeks,
day? You tell us any date of your
10th,
9th,
Ninth, very good.
November. Learned Counsel, Senior Counsel for us.
May I please, Lord? Lord, my
Yes.
friend has filed the counter also.
Uh,
That was served on me today.
uh,
I am ready to proceed with the matter.
uh,
But this matter arises under Trademarks Act 1998.
ready, Mr. Yes.
Lord, it's a defendant's revision arising out of a commercial suit. The respondent plaintiff, he laid a suit for infringement. The defense inter alia is that the trademark of the defendant is distinct and different. And that, my lord, he has been using it for the past several years, honestly and concurrently, without reference to the registered trademark of the plaintiff, which was only done in the year 2016. And that the trademark of the plaintiff is invalid. Since, my lord, it has not, there is a contravention and also there is failure to observe the procedure. That is a precisely defense taken by the defendant. My lord, I filed my written statement also. Last, may I kindly turn to page number 35, my lord. This is a paragraph number 3. Note, second line, Lashmi. In any event,
Where, which, where?
page number 35,
Ah,
paragraph number D,
ah,
about second line thereof.
yes.
In any event, plaintiff has allegedly made an application in the year 2016 and has obtained registration of their trademark without producing any cogent evidence. Therefore, the trademark is liable to be rectified.
But this is one place where we have specifically denied and we raised the plea of invalidity. Now, Lakshmi, kindly go to page number 38. Paragraph number 7, madam, in the middle. Starting with the registration obtained when plaintiff is defective, then she is liable to be rectified. But apart from this specific invalidity, I have raised other defenses also, which may not be relevant for the purpose of this matter. Madam. Now, in view of section 125, Lakshmi, kindly go on to this Trademarks Act. Madam. Since validity is raised, I filed an application before the appellate board. That application is pending. My friend has filed counter therein also, and it is coming up for my reply. Reply in the sense rejoinder. But at the stage it is lying. Now it was made over to High Court. Those proceedings. Now the fact is that proceedings are pending before the appellate tribunal regarding the validity. Now in view of section 124, Lakshmi, kindly take
Yes, madam.
Trademarks Act. I have been already intimated. Stay of proceedings. I just read. Subheading. Stay of proceedings where validity of registration of trademark is questioned, etc. Where in any suit for infringement of a trademark, the defendant pleads the registration of plaintiff trademark is invalid, or the defendant raises a defense under clause E of subsection 2 of section 30, and the plaintiff pleads the invalidity of registration of the defendant's trademark, the court trying the suit shall, if any proceedings for rectification of the register in relation to the plaintiff or defendant trademark are pending before registrar or the appellate board, stay the suit proceedings till the final disposal of proceedings. Now, the grand judge, in view of this specific provision of section 124, sued because validity has to be determined by the appellate board, appellate authority, tribunal. And the validity is whatever appellate board says will be final. That is what subsection 4 says. Lakshmi, kindly. The final order made by rectification proceedings referred to in subsection 1 or subsection 2 shall be binding upon parties, and the court shall dispose of the suit conformably to such order. So, whatever the appellate board says with regard to validity should be followed by the civil court in conformity with the order passed by that. Now, the lens judge, when I filed this application, he says there is no, I have not raised the plea of invalidity. On that ground, it was dismissed. Lakshmi, can you see the impugned order?
Para 11.
Look. I just, may I read it?
Yeah.
Only, third line. It is not the defense of the defendant with regard to the invalidity of trademark of the plaintiff. This is what?
Correct.
He completely.
34 is not treated. It says other persons. It's specifically liable to be rectified. It's not invalid. We are also rectified. No defense of invalid. Yes.
At another place also. Then, Lordship's attention, next page, there, it was extracted.
Page 14.
Yes. That's what that is the stranger part, paragraph 14. It is not the defense of the defendant that, Lakshmi, can you see? Paragraph number 14. He assumed something. It is not the defense of the defendant that both the trademarks are identical or nearly resemble each other. This cannot be requirement for pleading invalidity. Lord, he was under the misconception that unless I plead, both are Lord, dissimilar, similar, I cannot raise the plea of invalidity. No, that is what Lord, I'm trying to point out. No, the learned judge has relied upon a Supreme Court decision. He has taken it from that. And the Lord ultimately dismissed it. That is authority for the proposition that this Patel Field Marshal and PM Lord Diesel Limited. That is what Lord, it has taken from that decision. But this is what cited by other side in the type. But here, the point that was decided by the Supreme Court is, though it is with reference to the earlier Act, 1958 Act, but since the provisions are parametrically similar, the question that was raised, Lashmi Mechanism, paragraph number 9, it's page number 120. The question that was raised in that PM Diesel Patel Field Marshal is paragraph number. By reasoning, look, this is the paragraph. This is what coined by the bench. This is the question raised before the bench. In a situation where a suit for infringement is pending, wherein the issue of validity of registration of trademark in question has been raised either by the plaintiff or defendant, and no issue on the said question of validity has been framed in the suit, or if claim has not been pursued by party concerned in the suit by filing an application to the, at that time under the old act, it is before High Court, under section 111, read with 107 of the Trademark Act, whether recourse to remedy of rectification under 46 or 56 of the 58 Act would be available. This is where after exhausting the remedy before the civil court, and civil court says that you go and approach appellate board. If he fail to do so, then he can fall back, and then he cannot fall back upon registrar under 40. Now the act now as under the present 56 and 57. This is what it has been answered. That paragraph number 38. 38 at page number 130. Last paragraph. Look. This is no doubt, it is under the old act, earlier act, 58 Act. But the provisions are in parameter similar. The answer is at paragraph number 38. But that is no way concerned with the issue involved in the present suit, in the present application.
Page
Page
38.
Yes, paragraph 38.
Yes.
May I read it, Manoj? For my benefit. The mandate of 58 Act, particularly section 111 thereof, appears to be that if an aggrieved party does not approach the tribunal for a decision on the issue of invalidity of registration as provided under section 111 and 2 and 3, the right to raise issue of invalidity would be no longer survive between the parties, enable the party concerned to seek enforcement of the same by recourse to or by separate action under the provisions of 46R. Now it is 56R, 46 or 56 of the Act. This has no way application to the issue involved in the suit. In the present application, here the issue is simple, very invalidity is raised or not, plea is raised or not. I have raised the plea. Once that plea has been raised, the issue has to be struck. And whatever appellate board says will be the final with regarding to the invalidity of the trademark. That is how it is.
So order of appellate board cannot be challenged anywhere. It's final.
That recourse is different. That is aggrieved party can do it. No, so far as
Not final. It can't be final. Jurisdiction of this court under Article 226 cannot be taken.
Yes, that's true. That's why what in this case it has been decided. Once suit is filed, court has to give a finding. Then only jurisdiction under under the act will come into force before the authorities. That is what Lakshmi can see. In that decision also it has been stated. Look, page number 129, madam. Look, this decision has no bearing at all to the issue involved in the suit. Issue that has been raised before the court. Lakshmi, can you see page number 129 of the decision? There, it is paragraph number 31, madam. Page number 30. Last 4 lines. However, in a situation where a suit is pending, the exercise of jurisdiction by the prescribed statutory authority is contingent on finding of civil court as regards the prima facie tenability. That is what it has been said. But prima facie tenability. But that I have raised the necessary pleading. Issue has to be struck. But he cannot say that the plea which I have raised is not sufficient. But even if it is also, it should be before the board. Board proceedings are pending before the board, admittedly.
May I please? My friend has conveniently ignored one caveat contained in section 124. If I may draw your lordship's attention to 124 provision. If any, I'm starting at this second, clause B, my lord. If any proceedings for rectification of the register in relation to the plaintiff.
No, which provision you are reading?
124, 124.
Yes.
My lord, the second clause, first my friend has read. That is, if any proceedings for rectification of the register in relation to the plaintiffs or defendants trademark are pending before the registrar or the appellate board, I may just make one submission here. Now that appellate board has been replaced by Madras High Court. Because in the Tribunals Reforms Act 2021, the IPAB has been abolished and all the matters to transfer to the High Court. High Courts where the register is citus. Basically ours is Chennai. Our matters are transferred to the Chennai High Court. It is actively being pursued. Let me just continue. Stay the suit pending the final disposal of such proceedings. But the second clause, if no such proceedings are pending and the court is satisfied that the plea regarding the invalidity or the registration of the plaintiff's or defendant's trademark is prima facie tenable, raise an issue regarding the same and adjourn the case for a period of 3 months from the date of framing of the issue in order to enable the party concerned to apply to the appellate board rectification of the register. The procedure, what has been followed by the defendant in this case, my lord, it's upside down basically. What it ought to have been done is basically come to the civil court, express the invalidity, raise the same thing in the written statement, convince the court saying that the claim of invalidity is tenable, prima facie tenable. Only then he can seek the stay of the suit, not otherwise. Even this Patel Field Marshal case also,
Not really.
in
No, but in this suit, yes, the way it was the first time, why it was until not being right? You have not even said invalid, say rectification.
My lord,
Yes.
the bottoms-up approach, what is followed by the defendant, he has filed the rectification application before the IPAB, the erstwhile IPAB. And without taking the leave of the court or without convincing the trial court about the prima facie tenability of the claim of invalidity. Now he has come up with the petition of under 124. Even this, my lord, the order also, my lord, the impugned order also, in the finding that is in at page 17, it's my, it's, paragraph 17, page 15, my lord. The impugned order.
Hmm.
The sentence starting in the middle, my lord, thus the defendant failed to satisfy the requirement of the civil court to frame an issue regarding the invalidity of the trademark of the plaintiff. There is no approach. I mean, there is no approach by the defendant to the court saying that this mark is invalid, and therefore to the satisfaction of the trial court. So there is no such petition filed. Instead, they went ahead with the filing the rectification proceedings before the IPAB, which now stood transferred to Madras High Court. Then, I mean, in the absence of such basic requirement, the defendant is not entitled to seek the relief of stay of proceedings in order to vest the jurisdiction of the statutory authority. Therefore, this court is of the considered view that the petition lacks merit. This is a clear-cut finding, my lord. Even the Patel Field Marshal decision also. The journal which I am looking at, my lord, is different. So the corresponding paragraphs, you know, in order to, I mean, the reference to be right.
No, Mr. We need not go into all these questions. We don't know. It's a lack of pleadings on that the application has been dismissed.
That is not the only criteria, my lord. For 124 petition, if one is seeking the stay,
Criteria means which other ground it has been rejected. Tell us from the impugned order.
that is what, my lord.
Which other ground it has been read the order.
The two grounds the lower court has dealt with. One is with respect to the invalidity, question of invalidity. No doubt that the question of invalidity has been raised. But there was no prima facie case which has been demonstrated before the trial court. In order to seek the, permission of the civil court to go there.
No, what is the other ground? You said that that's not the only ground. So
Yes,
which
my
other
lord.
ground it has been rejected? We are asking.
The last paragraph, my lord, the finding is very clear. The defendant failed to satisfy the requirement of the civil court to frame an issue regarding the invalidity of the trademark of the plaintiff. My lord, the invalidity has to be demonstrated, my lord. In the absence of such basic requirement, the defendant is not entitled to seek the relief of stay of proceedings. My lord, even this they have not, instead of obtaining the leave, they went ahead. My lord, even the Patel Field Marshal case, my lord.
Just to make out, therefore, the court has recorded in para 17 many things that we are not understanding and that we have understood what is trying. Not that difficult. We have understood, Mr. It's not that difficult case, right?
It's not a difficult case, but the basic requirement is required.
I mean, we have understood. What else now? Yes, go ahead.
My lord, I may just draw your lordship's attention to the citation. Patel Field Marshal again. This is in a different journal. So the reference will be clear in it. For the child.
Give
There
the-
again, what is happening is, before the Madras High Court, my lord, I am resisting the admission of the petition. On the only one ground, my lord, that is, in this decision, my lord, I may draw your lordship's attention to paragraph 30. Paragraph 30, my lord. It's on page 9. In the middle of this paragraph, my lord, paragraph 30.
Yeah, different. No, no, different citation. Yeah, yeah.
I read paragraph 30, my lord. In the middle, the tribunal will, however, come into decision of the matter only if the civil court is satisfied that an issue is with regard to invalidity ought to be framed in the suit. But there is no frame of issue as such. So far, there is no such a petition has come up before the trial court. My lord, on this precise ground, my lord, I am resisting the admission of their petition before the Madras High Court, my lord. On this precise, because unless the issue is framed, the court cannot come into decision of the matter. That is what the Supreme Court observed, my lord. Once an issue of this issue to the said effect is framed, the matter will have to go to the tribunal, and the decision of the tribunal will thereafter bind the civil court. In as much as to say, my lord, maybe I am reiterating that. What types of approach was followed by the defendant? Convince the trial court. The trial court, if satisfied the provision mandates, it is not something else, my lord. The provision 124B2 very clearly says, succinctly says that if no such proceedings are been, my lord, admitted fact is that after filing the suit, these rectification proceedings have been filed. After filing the suit, it is not before the filing.
How much time will you take to conclude? Then we will admit the petition. It requires, we thought it's an issue we could have decided right away. But according to you, it's a very complex thing. We will admit it.
Nothing complex matter. I may just have to take another 2 minutes to convince you. No such proceedings are pending and the court is satisfied.
Repeating. Yes. Conclude, Mr. in 2 minutes if you can, otherwise we will admit it. Hear it at after 5 years. Yes.
Because there is no prima facie tenability that has been satisfied, my lord, that is the reason.
How many times? The third time you are telling us.
It is mandated in provision, my lord. That is what I wish to submit, my lord. Even the Supreme Court also makes the same similar finding, my lord, in the decision. The petition is liable for dismissal.
Yes, anything else? That's
Nothing to add.
yes.
This is
In this petition and
My lordship, for the petition lordship through online appearing.
Yes.
I
Yes.
request time lordship in the 2 weeks lordship in this complete petition is filed by third parties.
Huh?
I need to file counter in this complete petition lordship.
Somebody is like,
Last occasion also, the time was short, I'll only say that, but not more than that. They are proceeding with the construction, but I have told them.
yes, Mr.
Lordship, this complete petition of third parties, lordship, I need to file counter because of there is no way consent to this. Lordship, as soon as the matter is lordship in favor of me, lordship, it will follow all the parties, lordship. But I will file counter lordship, formal counter lordship, because
No, what he wants is that you should file within a week or so because you are going on with construction.
lordship already much before this lordship we have constructed lordship. There is nothing more to lordship in this. Lordship, we will file counter lordship with
You like, so week's time?
2 weeks lordship because of he's out of station.
Maybe almost 2 weeks, majority of the construction may be completed. But next week, maybe last occasion also time.
Why do you want to? This is not a case where you should seek adjournment, right? You have an excellent case. Single judge in your favor. Despite that, he has declined to grant you the relief. We don't understand why you are not following the case and seeking adjournment.
10 days lordship because of he's coming within the 1 week. He's coming lordship. He's out of station. I'll file counter lordship. The formal counter I'll file because of the third party.
Mr. How are you? How are you?
I have purchased from the respondents 4 and 5.
So,
Subsequently.
what is this? He had filed. He was granted a building permission, right? If he doesn't want to argue, we will put you questions.
Yes.
He was granted building permission, correct? On 20th July 2022.
Yes.
Right? No, on 24/8/21. That building permission has been cancelled on the ground that the same has been obtained by misrepresentation and fraud, right?
Yes.
So the learned single judge has found that there is no fraud and misrepresentation. So what is the necessary corollary?
However, the learned single judge.
As said that you file a civil suit, why he would go to civil suit?
May I say, Lordship, I'll only say one submission.
Huh.
But in fact, after dismissal of the petition, he files a suit
No,
against
no,
me.
see, he has a building permission in his favor. That order of cancellation of building permission has been set aside by learned single judge. If you are aggrieved by his action of being in possession and raising construction, you should file a suit. What we will do in his appeal.
That exactly,
You should, there has to be, we can't believe that there is no forum to challenge a building permission granted to a person under this thing, Municipalities Act. There has to be a forum of an appeal. You go and file an appeal. If you have a dispute with regard to title, go and file a civil suit, seek. If there is no statutory remedy, seek injunction, restrain him from raising construction. What will happen? We can't can the scope, your presence of this intra-court appeal be enlarged? Tell us. You should seek, Mr.
Two things,
We will clarify that any observations made by learned single judge will not prejudice you in any of the proceeding which may be instituted by you with regard to your grievance, and that will be dealt with its own merit by the forum or court which you approach. This we will do.
One more thing which may come in my way, even if I succeed in the suit. But since his construction is, if it construction.
Seek injunction. He is a private individual. We don't know why he is seeking time. He is a private individual. Seek injunction against him.
May I interrupt your lordship?
Please.
One submission.
We just want to know. He is in any way seeking time.
Exactly. What happened was after dismissal of the petition, he filed a suit against me. That was never stated below in this before.
All right.
That was never. Is one submission.
Yes.
Second one is that I filed in the appeal also.
Do you think that in a writ petition, like in a writ appeal, we will pass an order of restraint? You have to take, if you are aggrieved, there is an order, there is a building permission in his favor. He is raising construction in accordance with that building permission. You take recourse to either the statutory remedy, if that is not available, take recourse to remedy of civil suit, file a suit today itself, seek an injunction against him,
So equity,
restraining him.
equities may come in my plot because if the.
Why equity? Nothing. No equity. That's what we will say, that the order observations made in the order will not come in your way for two reasons. Because the scope was confined to examining the validity of the order of cancellation. Secondly, you are not a party to the proceeding and you will be at liberty to prosecute your own independent remedy in accordance with law, and these observations shall not come in your way.
Them not claim equity is also not subsequently. Even if I succeed in the suit.
What
they say
is
that I am sure invested.
Mr. Injunction, you will be, if you will have to seek an injunction, right? What equity? Much will depend on whether you are able to get an order of injunction. Then the question does not arise. There is no point in this thing, Mr.
Other hand, my lord,
Huh?
they approach this honorable court. My other hand, they have an alternate appeal, my lord, before the under municipal last minute. Your lordships also.
But what to do? The learned single judge has entertained the petition. What to do?
Very well.
All right. So we will clarify this order.
Yes, sir.
We'll clarify the order to that he is not a party. How can he be prevented from taking recourse to any remedy which may be available to him in law? Right? We can't prevent him.
But in fact, the writ appellant will not already not file the civil suit against will not be
Huh?
by virtue of the orders passed by the learned single judge. The writ appellant already filed the
Still,
civil suit.
the fact remains that the building permission as on today stands.
But that is what blood by virtue of the orders passed by the learned single judge. Writ appellant already availed the remedy of not filing a suit, but the suit is pending. But when he has not obtained any interim order in the suit, but then he filed the writ appeal by suppressing.
No, Mr. He has filed a suit. That's fine. We are not doing anything to him. We are in fact not passing any order. We are only granting the liberty to the parties to take. He should file a suit. If you supposing you are the local body, right?
Yes.
If he is raising construction in violation of building permission or illegally, you have power to stop it. Why do you want an interim order from this court? If he wants an order of restraint, he can file a suit for injunction.
Now, an application filed by the unofficial respondent was asked him to revoke the building permission granted in favor of the writ appellant. Then we have issued notice to both the parties and not after after considering the rival claims, we have
do whatever, Mr. What we are talking about this appeal, not something else.
we have already revoked the building permission against which the writ petition is filed by the writ appellant.
But there is a finding, right? How can you establish this fact in a summary jurisdiction?
It's only title dispute. That is the reason the learned single judge.
All right, you want an admission of the appeal and don't want to do anything, right? Because you can't displease him nor you can annoy him. So you want that this appeal should remain pending. What is this, Mr.? What are you arguing? This is, you tell us how this is how are you aggrieved by the order of single judge? Parties have been relegated to avail of the remedy of civil court.
That party has already availed that remedy and he already filed the civil suit. Then by suppressing that fact, we filed the present writ appeal.
We are not doing anything in his writ appeal. If you have, Mr. Is it like this that one time we have to explain it to him, second time to you, then third time to him, and after only you are convinced we should pass an order? It's not like if you are aggrieved, further forum 136, go.
Yes,
We are not like sitting here to convince you, Mr. We will not entertain. It can't be by way of an intervention. The scope of the appeal cannot be enlarged according to us. If you feel it can be enlarged, he can go. You can also go. We are not doing anything. Yes. So we'll clarify this. Yes.
Lordship, the same line of lordship will be disposed. I request lordship may be disposed.
That's why we felt surprised that you are seeking an adjournment.
Because I thought lordship the including petition should be.
This intra-court appeal has been filed against an order dated 20th July 2022 passed by learned single judge, by which writ petition preferred by the appellants have been disposed of with the liberty to the In fact, we should.
That is suit filed against this proposed implementation as a permanent injunction, Lordship. There is no declaration
Yes.
suit, Lordship. As after purchase, the pending writ petition, Lordship, this purchase happened, Lordship. Because of by virtue of that purchase, illegal purchase, these third parties trying to interfere. Then I filed a suit. This petition filed injunction, Lordship, against this third party, not the original owners. The original owners are not the party.
We have read no respondents as well as appellants as well as respondents and proposed interveners. Well, no, nothing. IA are disposed of. Ah, yes.
All go together.
10,
11 and 12 items, sir. All the three matters go together. At the last occasion, you will also
record.
government leader.
You have got the record. Would you like to see go through? You may go
Yes,
through.
no, but the information that was sought from the Learner government leader is whether that 38E certificate has been issued by the revenue department in the year 1975 or not.
Yes.
That aspect.
Not issued.
It is not there, bro.
But you supply to him. He is the person eventually. We will take it up tomorrow, day after, whenever you want. Next week, Monday.
Yes.
In compliance of the order dated so and so, learned additional government advocate has produced the record. Let a copy of the same. Let a photocopy of the relevant record be supplied to learned senior. Amendment you have filed.
Yes.
Heard on IA number so and so, taking into account the nature of proposal. Yes. Mhm. Counter is not filed,
Today we
Mr.
are filing, no?
Today.
Copies are to
Copy is so not. So tomorrow is the last date for the admissions process. Once
Tomorrow then. Tomorrow.
tomorrow is the last.
All right. So Learned Council undertakes to file the counter during the course of.
If they get that information also, Lordship, your Lordship, it's easy.
Find out what information he wants.
That I appear for the respondents for that 1 to 8. On the previous date of hearing, your Lordship was pleased to direct the petitioner to delete the name of the 10th respondent, who is the first class judicial magistrate.
It has been deleted.
That was deleted, my lords.
My submission to your Lordship would be, my lord, now it has been deleted. So, subject to your Lordship's correction, my lord, it may go to the single bench, my lord. The allegations against the police officials for the high-handed manner.
So let it go before the roster bench.
Yes, my lords, no problem.
Let
Tomorrow, my lords.
as early as possible. Let the writ petition be listed before the appropriate bench.
tomorrow, my lord.
So what you are not filing counter,
Filing counter today, my lord. Received counters and
same order, says
16 and 17. Okay.
place tomorrow, same order.
16 and
16 and 17, right?
May please your lordships, my lord.
Yes.
Item 18, my lord.
Yes.
My lord, the removal of the my lord, petitioner who worked as a court manager, my lord, has been challenged in this writ petition, my lord.
We'll see. We'll list it before division bench 3. Let the writ petition be listed before division bench 3.
Obliged, my lord.
It's an order on administrative license. The matter has been dealt with on administrative side, so therefore let it go before some other bench. Right? Division bench 3.
Right. As per this humble lordship has already filed suggestions. Kindly permit me and read the suggestions.
Mental health.
My lords, on 22nd September, my lords have directed us to give the list of destitute persons, my lord, and the patient psychiatrist ratio, as well as the facilities offered to the patients.
What do you say, Mr.? What is your response to this?
Willard, I filed suggestions for issue direction to authority. Issue direction to authority for allow this public interest litigation for establishment of the rehabilitation center in each district, Willard, for implementation of the.
You have said that it is done already.
Done.
What is your response to this? You, Mr. This is not a petition for direction against anyone. I think it's a. No. This is with a salutary object of providing facilities to persons who suffer from mental health issues.
Yes,
so approach should not be that I have. They have said that is it enough? What is your response?
I am the response, Millard. I am implement the act, Millard, entire and suggestions, total suggestions submitted before his humble lordship.
When have you? He is not concerned with it. He is done, right? So you let us, we have to examine, he is not able to provide assistance to us. There's no point.
My lords,
You tell us what have you done?
my lords, may kindly go to page 3 of the additional counter note filed on
There is.
18th October, my lords. My lords, the direction is at the top of page 3, my lord. My lord's direction that, my lord, may I read the direction, my lords?
What have you, this thing?
My lords, in compliance of the directions, my lord, we have given item wise, my lord. Item 1 at page 3 bottom is total number of ill health district persons, patients undergoing treatment in the Institute of Mental Health, Erragada, Hyderabad, and other districts in the state of Telangana. But the total number of patients in each district is given, my lord. But page 6 is the second direction, my lord. That is patient and psychiatrist ratio. Page 6 tabular form is given, my lord. But the middle column, it shows as 1:2 blood out. For every 4 patients, there is one psychiatrist attending blood. That is sufficient blood. There won't be any difficulty in treating them, my lords.
No. Millard, what I am submitting. It is 1:4 to 1:18. What does that mean?
My lords, if postgraduates,
1:4. Some places 1:4 and 1:18.
but PG
Will that
students,
be sufficient? Will that be sufficient?
my lords, the previous column is if postgraduates who are serving there are not counted, then it is 1:12, my lord. But next column is psychiatrist ratio with PGs, postgraduate doctors. But those who are pursuing PG will be there in the particular hospital for 3 years, my lord. They will also be treating.
Millard, and
In
just 1 minute.
compliance of the order date.
Millard, 1 minute. My Pill's intention is different. By this authority's submission is different. The authority's submission as a calculation of how many members is registered in the
In compliance of the order
Yes,
date.
Millard. My pill is a establishment of the
No,
government
forget
sector.
about it, Mr. It's not your pill.
Yes,
Once cognizance is taken, it is the court's public interest
Yes,
litigation, not your, forget about it.
Sorry for that, Millard.
It's not a trademark,
Yes,
right?
Yes,
That,
yes, Millard.
my pill.
Yes, Millard.
Nothing, forget about it. You have lost locus.
So,
Sheila Barse, you
Yes,
have lost locus. Once you have brought pill, you are dealing with it in our own way.
Millard.
In compliance of the order dated 18/10/2023, comma, the
Well, it's, I'm appearing for appellant's village. My Lord Senior Justice Nyas Murthy has been requested to lead us into this arguments village.
I appear for the respondents. I will only request, though I have been engaged. Merit, after going through the voluminous record, I thought, Merit, I would request your lordship for some accommodation of time. Because there are too many proceedings. There's a lot of record, Merit, that has been.
which day? Give us an agreed date.
It was an agreed date, if your lordship recollects, Merit. In fact, the lordship wanted to hear it in October itself, before vacations.
You see your friend's difficulty, right?
From 85, I'm agitating, Merit. My list of dates, everything is ready. A lot.
No, but you have just now heard him, right?
Yes.
So that's why
The only thing that,
next week sometime.
next Monday,
No, your lordship, because this I'm representing the work of your lordship. Problem is that due to this election code, we could not conduct the board meeting. Fixing the remuneration of the senior advocate, your lordship, you are engaging that.
the first time, you please be taken for adjournment, Merit.
No, that's after next month, any date your lordship, we can.
But I had filed a vacate, your lordship had discussed vacate, secretary, your lordship is hearing the main case itself today, Merit. In fact, it was supposed to be heard on October 17th. But then subsequently was changed to Merit today.
No, that will not be ground for adjournment that they are unable to hold the meeting.
And
We are not
newspaper
concerned.
petitioner senior speak that too. I would only put it shortly on my inconvenience because I was ready.
So which day? Tell us next
20th.
week any day?
On 20th Monday, Millet.
Monday, 20th. Next Monday.
Next Monday, Millet. 20th Monday. No, but next Monday, Millet.
Next Monday.
Yes.
That's what he's saying.
Yeah, 20th, 20, 20.
20.
That will 3 weeks after Monday, I'm asking.
Oh.
No.
After.
A week after Monday.
You were saying next, if you want.
But I wanted it on 20th. But I don't know, Millet, I filed a vacate. You don't maybe making such a request to my friend. But I had a vacate. Vacate was dismissed only on the ground that it was heard on October 17th. But subsequent, because other issues raised on the day, it was decided that we heard today. In fact, your Lordship wanted to recuse from this, and your Lordship said, finally, here is this matter on this day.
No. It's okay. Please.
Indeed, I can still understand.
Give us, it's better you give us an agreed date, Mr. Instead of refixing.
20th, Millet, so that I need not ask for any further time. Next 3 weeks, Millet. I'm saying next week. Already it was 4 weeks was granted earlier. It was fixed today, after vacations.
13th is the holiday, Monday holiday, your Lordship, Diwali.
So therefore, I'm saying next Monday. From 85, I'm stating, Millet. The first award has been passed because Neeladri on 1985.
Can it be on 6th, Mr.?
Yes.
6th.
Yes, ma'am.
Yes, Mr. 6th November.
Short melody, your Lordship may accommodate some day.
There's nothing, it's not that difficult, Mr. We have also gone through the impugned order. It's not that with your experience, for your experience and skill. Not that.
14th, your Lordship will consider, but at least for 14th. List of dates are ready, I can pass on to my friend also.
We are ready to hear, Mr.
Be done by us also.
Well, my friends, anxiety need not take away. Well,
85, if I don't have actually go else from 1985, the award is for 85 just by just Neeladri Rao.
No, then we have not rejected your application for vacation stay. We can hear it if you want it.
Yes, my vacate petition.
Vacate petition, then in case, he is insisting, we will decide.
14th minute. One go minute, both the arguments would be one and the same.
All right,
Petitions as well as the main hearing.
But one of 2023, taking into account the fact that the appeal is
I'm sorry for the.
No.
We are grateful, minutes.
Item number 33 minutes. The earlier council on record has passed it in minutes. They've given me instructions to appear in this minutes and not received the wakalat clause.
No, we are authorizing you to appear. What is that? You tell us what is the case.
I have not received the entire file.
We will give you the file.
Lodgement accommodate me with 2 weeks.
See what is. We have also not read it.
So like,
We also don't have any instructions, right?
the notices were received.
It's on 5th minutes, October, Lordship was pleased to order notice to the petitioners. Since
Huh?
council died minutes, notice was ordered to the petitioners.
17 years, Mr.
My lord,
Have pity on the petitioner, he has died.
the lordship's kind of
Nothing, Mr. Yes, please. What is the order? This is a writ petition, right? What is it about? Go through it. Take your own time. We are not in a hurry. Tell us what is it about.
So prayer is not to evict without due process, following the due process of law. That's a kind of.
That we will grant. Petition allowed. He will not be evicted except in accordance with law. Right, Mr.
In their own affidavit, they say, an eviction order has been passed against them.
No, no. But to execute that order of eviction, you will have to take recourse to law. He can't be thrown out. You evict him in a manner known to law. That's the only relief. Its petition is allowed.
What happened to this writ appeals batch 1769 and 1792 of 2001? Go to page 13.
Yes. Seventeen sixteen and 1792, unless they were disposed of.
Are you aware of those orders? What happened in those appeals?
One minute. What is the petition?
Paragraph 11, of the writ affidavit.
We will say that this thing is saying that they should be restrained from. That's what we will grant. Mister, if you have to take any action for their eviction, take in accordance with law. That is the prayer which is being made. There's no point in keeping this petition pending, right? You can't, Supreme Court says you cannot throw an encroacher also forcibly, right? Take this
Leaving
thing.
it open, to the,
Ah.
because the eviction orders are passed and all
Yes.
the sale transactions.
Execute the
taken
eviction.
place in this-
Execute the order of eviction in accordance with law. That's the only relief. Yes. See, they are more than contented, right? See, why were you seeking an adjournment for this? We are allowing your petition.
That's only their case is they have made an application for regularization. Pending that they are not.
Is there a stay in here? They have purchased the plot. They have purchased plots, right?
It's Gurukul Trust case, sir.
And in fact, Lordship may kindly have a look at the docket dated 1/11/2022. As regards this entire property, one SLP is pending before the Honorable Supreme Court. That's on that ground, petitioner sought time on 1st November 2022.
No. We will. Yes, confined the relief.
Bringing it to your Lordship's notice, that was the proceeding sheet, of
This is what, see.
1/11/22.
That's what he says. Who are these people?
That's paragraph 10.
Who are these? What are the facts, Mr.?
As they claim to have purchased the property, the subject property, and all the transactions were held to be void, and government issued QMS 703 dated 30th/9/2000, nullifying all the sale transactions. That was put to challenge before Dishonorable Court. Dishonorable Court upheld the GO and given liberty to the petitioners therein to approach the government for regularization. Whereas the petitioners have not.
No, they have purchased from whom?
Paragraph 4, They have purchased.
Have they purchased it from trust?
They claim that their vendors purchased from the trust. Their sale is at page 15,
And what are the facts, Mr. that you don't know? All right.
Whereas the petitioners claim to have purchased the property under registered sale leaves and their claim is that they are.
From whom, mister?
Whereas the sale deed is page 15, my lords. One D. Mallareddy. That's page 34. The interim order, my lords, of the then single judge, my lords, which details out, my lords, the entire history of the land.
So this is your prayer, right? You should not be dispossessed except in a.
Page 40, that's page 44. Order of the land single judge in similar circumstances. Page 44, my lords.
Yes, madam. In this writ petition.
In this matter,
May I please, Malad?
Yeah, this all must have been infructuous.
Malad, this has not become infructuous, Malad, and this honorable court was pleased to grant stay of all further proceedings, Malad, by an order dated 9th August 2006, Malad, and which was made absolute by this honorable court on 13/11/2006, Malad. But the innocuous relief, Malad, which is sought in the present writ petition is, Malad, the debt recovery tribunal, Malad, without disposing of the interlocutory applications filed by me, posted the matter, Malad, for trial. And
So we will allow your writ petition. We will direct the debt recovery tribunal to decide interlocutory application before deciding the main matter.
Yes, Malad. That's all, Malad, I am saying.
This is 2006.
Yes, Milord. In fact, Milord, your Lordship may kindly see when this honorable court made absolute, Milord, the interim order, given liberty, Milord, to the respondent for applying for early, but they have not sought, Milord, any such thing, and it is pending like that, Milord.
Who has filed OA?
OA is filed by the bank, Milord. It is the bank OA.
Why?
For recovery, Milord.
Oh, recovery.
Yes, Milord.
Under the 93 Act.
Yes, Milord. Under the 93 Act.
All.
And they do not wish to, Milord, produce the documents, but which are core for my case, that the they have changed, Milord, replaced the guarantees, and that record, Milord, they are not producing. And there is a checkered history even in the earlier round, Milord.
No, we are not concerned with any history.
Yes, yes, Milord.
Yes.
Therefore, impugned order needs to be set aside, and the DRT may be directed to decide IAS, Milord, first, and then proceed with the trial.
Which impugned order?
There is a direction that is used.
Now, will you tell us some facts, right? What happened? You had taken loan.
No, but so far as I am
You are a guarantor.
Yes, Milord.
Guarantor to the loan.
Yes, Milord.
Oh, it was availed by whom?
Availed by the Rama Organics, Milord, the third respondent, Milord. That's the company, Milord.
All right. So what happened? Suit was filed.
It was
OA was filed for recovery.
Yes, Milord. OA was
under
filed
section 19.
Yes, Milord. And then, Milord.
Then what did you do in that way?
But in the OA, Milord, there was a direction that was but earlier when IA is filed, Milord, they did not produce
which IA? What are the IAs? 354.
Milord, there are 4 IAs, Milord, which now I saw. Milord, earlier,
No, you have filed 4 IAs.
Yes, Milord, those 4 IAs, Milord, your Lordship would find.
What is, you tell us, what is it?
The IAs for summoning of the documents, Milord, and for summoning of the record.
Now what is IA 354?
But IA 354, but you also would find at page 23, my lord, IA 354. I find all those IAs, my lord.
Not prepared to tell, right?
But I'm sorry.
No, we should find out. You will only tell page number.
No, not like that, my lord. It's only for
Yes. When we are asking what is the IA,
but the
you are
IA
saying
is,
page 24.
but IA is, my lord, to produce the officials who signed and dealt with the documents, my lord, which they have listed in para 2 of the affidavit. There is a list, my lord.
Now 1964, what is IA 1964?
But that 19664 is, my lord, at page 34, 29, and that is, my lord, for producing of the evidence, my lord, of the originals of the office notes, my lord, of the head office and regional office in respect of this loan account, my lord.
See what like pending since 2017 years.
Yes.
Hmm. Double
And another IA is, my lord, for producing the original guarantee agreement, my lord. That is 1177, my lord. IA 588, my lord.
So what happened then?
But all those IAs, my lord, are kept pending, and the learned judge posted the matter, directing me to cross-examine without my lord deciding those IAs.
Where is that order? Where is that order?
25, 25/7/2016, my lord, is the order that I have filed, my lord, at page 47, my lord. Page 47, my lord.
See what? They should have this thing. Yes, madam. In this
Lord, I'm appearing for the respondent in this matter. The subject is very short in brief, my lord. They seem to have made a representation before the MRO, my lord. The petitioner before your lordships has made a representation before the MRO and she's seeking her prayer to dispose of the representation. Your lordships may direct the representation to be disposed of within 8 weeks.
This is the only case pending since 2006.
My lord, there are parallel proceedings which were going on. One set of the assignees, my lord, the order is challenged and that is pending before the Supreme Court. Whereas this lady is saying, my lord, he was not given an opportunity of being heard. Against the order of the MRO, she straight away come before the Honorable High Court, my lord, instead of preferring a appeal before the RDO.
That's the only prayer. Direct them to dispose it within 3 months. Madam.
My lords, as per the judgment of this Honorable Court dated 5/7/23 in writ appeal number 743 of 2014, this writ petition is also liable to dismissal.
For the reasons assigned, this for reasons assigned by us in assigned by us in the judgment dated 5/7/2023, passed in WA number
743 of 2014.
14, this writ petition is also dismissed.
Kindly pass on, Lord.
Why?
My senior is unable to log in, not kindly.
Unable to, but you are able to argue, right?
My senior is appearing in this case. Kindly pass on.
It's only a publicity interest litigation.
Publicity. And then PIL is nothing, Mr. Then you forget about it. No question of pass.
Not one submit.
No, you have lost the locus, right? Once the PIL is entertained, what is Sheila Barse say? You cannot withdraw it, you cannot this thing. It's our, this thing, court has taken cognizance Now if you want to assist. Don't be an impediment in dispensation of justice.
Only request kindly short pause.
Nothing.
Short pause.
This is PIL, right?
Yes, PIL. Yes, ma'am.
What is it?
Kindly.
You will not get anything.
May I please, Bharat, I just apologize,
yes.
Bharat.
Yes, please. What is it?
But the public investigation is filed
Ah.
by taxpayer man complaining that the taxpayers' money cannot be diverted for religious purpose as per the GO issued by the state government. But at page 16, man.
Hey, but what now? 5th June 2006 is still there?
That if the Telangana government, but now it was issued by the combined state government.
Ah.
If the presently it is no, my lord, the Telangana government says that it is implementing that GO, then the cause of action will be still there.
See, Mr. Our predicament is the moment we ask any question to any of the councils, they will seek adjournment. We will conveniently seek an adjournment. Our predicament is 2006 matter. We don't want to. She is already smiling in anticipation of an adjournment. What to do?
Not that way.
We are afraid, but you should think about it. It may not be enforced, right? We will grant you the liberty to, in case, what we will do is, senior counsel, that we will grant you the liberty to revive the prayer in case the issue survives consideration.
May I make one request, Bharat? I'll make one small request. You'll actually give the liberty to the petitioner. But if it finds that Telangana government is still continuing with that policy, then he will.
Yes. That's what we said. Fine. But you should, Mr. Your junior should do something. Huh? You should not have been required to appear for this. He should have, this young man should have been able to tell him. He should have told us. That's the issue.
Usually, my lord, such things, my lord, usually, if I can take the liberty of dispose of like this, that's all.
Yes. Mark the presence. In this writ petition. Ah. Yes. What is it? Hmm? This appears to be a bunch from 41. Mhm. No, I'm saying 41 is fine. Hmm?
Government had filed the appeal, your lordships, with a combination of delay sections. That was dismissed.
And the moment we dismiss, we will file. Decided, whatever is.
Government's appeal, there was a convention delay.
With regard to the entitlement of the writ petitioners and the appellants herein below, of their protected tenancy, writ petition has been filed. Lord, the council is appearing for the respondents, unofficial respondents, Lord, who is the possessor of who is a protected tenant, Lord. Between the parties, private parties.
Ah.
They are not appearing. Even the last occasion, but they didn't appear.
Protected tenant. There are two findings of the single case. One is that the petitioners are the protected tenant, and that the Tenancy Act will prevail over the administration of Right to Property Act. And therefore, with these findings, the writ petition was disposed of.
See, we have two options. One is to dismiss for default. In that case, tomorrow itself, restoration application will come and he will give a mention memo.
Or on the caption for dismissal, my lord, so that.
The other thing is we decide it on merits, no? Why to keep it pending?
Well,
The governmental side has not filed any appeal. So that decision of the single judge has become final.
Mr. Srikanth, there was a direction to the petitioners to approach the authorities. Have they approached? What happened subsequent to the passing of this order?
there is no.
Writ petition 26860 of 2003.
Yes, they are third parties. The appeal.
This writ petition is not WP number. Yes, no, 2686.
These people are not parties to the petition. The appellants propose. Don't know why and how they are agreed.
Grounds of appeal.
Extra copy.
Leave has been granted.
Wallet grounds, third party. Government, yes. Government appeal, as it is. Only the third party appeal is there, your lordship. And there is no concern whatsoever with the land. He claims to be the.
Not seeing his submission, Lord. Against the very same order. Against the very same order, government had preferred a writ appeal. It was dismissed at the admission stage itself without condoning the delay.
Which?
That number, Lord, I'll verify by you.
Number is there.
That's what's his submission.
That's what it's. WMP 1110 of 2008.
WA number?
WMP number 1110 of 2008. It was a petition to
At the
condone
SR
the
stage,
delay.
without condoning the delay. Without condoning the delay, at the SR stage, it has been dismissed.
What is WA number?
Writ appeal.
WA number was not, it was only WASR number. It can't be WA.
So whatever.
Without admitting, Lord, without numbering at this.
What is the number?
I'll find out.
What is the number?
WSR number 14,009.
Huh?
1 lakh 40.
124 122. No, 124 122.
Is it?
You will only say it has been affirmed. None for the, yes, madam. None for the appellant mark is their presence for whom.
But please, your lordships. My lords, on the last occasion, the respondents filed a counter affidavit on 3rd October 2023, wherein they have stated that 1,19,000 acres are to be restored to the STs, scheduled tribe territories. Having considered that statement, my lords directed the learned government leader to file an additional affidavit.
That I have filed it with the subsequent developments. I am also indicating the extent
This
that
is a PIL. So what do you say with regard to additional affidavit? They have taken step.
Their additional affidavit, they said that still 13 acres are to be restored. even as on date, 1,13,000 acres are to be restored
No, no,
in favor of
that's not
SCs.
correct. But I'll just read my additional approval. Your lordship may kindly. Para 4, your lordship. Previously, in the counter minute, we have stated that 81,334 was restored acres. But in the present counter minute, additional counter, your lordship may kindly see, it is submitted that the competent authority have detected
Para
para 4 minute.
in addition to para 8.
Yes, madam. It is submitted that the competent authority have detected 52,142 cases under the provisions of Telangana Scheduled Areas Land Transfer Regulation 1959 as amended from time to time, covering an extent of acres 2,62,035, of which
2,60,000.
23.
2,574 acres.
Yes, ma'am. 2,06,235. Your lordships are seeing the latest counter bill filed in October 2020.
1st October.
This was filed on 19th October. Right?
So what is it? We have been given this thing. Two documents. One is additional affidavit.
Additional affidavit. I'm reading the additional affidavit.
Para 4.
Para 4 from time to time covering an.
No, not from time to time.
In addition to para 8,
it is.
It begins. It is submitted that the competent authority have detected 52,142 cases under the provisions of.
No. 19th October.
See, the counter filed by you on 19th October.
Yes, yes.
Counter affidavit.
Additional affidavit. Counter affidavit by R3.
This is in addition to para 8.
Yes, in addition to para 8, it is submitted that the competent authority have detected 52,142 cases under the provisions of Telangana Scheduled Area Land Transfer Regulation 1959 as amended from time to time, covering an extent of acres 2,06,235.71 acres, of which 51,021 cases were disposed of. Cases detected are 52,142. Cases disposed are 51,021. Therefore, the balance is 1,121 cases are pending. Out of which 51,021 cases were disposed of, covering an extent of 2,01,768.02 acres. Out of total disposal of cases, 31,764 cases were decided in favor of the scheduled tribes, covering an extent of 1,10,201. It is submitted that as many as 92,383 acres are restored, 24,874 scheduled tribes. This 92,383 was earlier, in the previous counter it was mentioned as 81,334. Subsequently, certain cases were disposed of. Therefore, the restoration figure has been increased to 92,383. Acres are restored to so and so families. The district-wise details are furnished in Annex 1. It is respectfully submitted that 496 appeals, writ petitions covering an extent of 2,909 acres pending disposal in various courts. The details are furnished in Annex 1. It is submitted that the contention of the petitioner that the tribal lands are not protected is totally untenable and I have to be rejected. The cases which are pending also, I have mentioned here. The balance is at page 6, your lordship mechanism. Page 6, Page 6, Land restored to tribes last but one column towards right side in the table.
Kindly see minute the total minute, towards bottom minute, total is 92,383. My lords got it minute. Then minute, the balance minute, 4,467 has been decided to be restored in favor of the tribes as the cases have been disposed, but this is yet to be restored. It is under process. And what is to be decided minute in the cases is at page 7 minute, annexure 2. I have given minute the district-wise cases which are pending in various courts minute. The first is minute project officer ITDA. These many cases are pending. Government after the ITDA minute then appeal lies. Before the government there are certain cases. In High Court also minute there are certain cases. Total your lordship may kindly see. It's right side minute 496 cases are pending. Covering minute 2,909 acres only. These appeals have to be disposed of. The cases have to be disposed of. Then this 2,909 will be restored, depending on the result of the case. But what we have to do is immediately is 4,467 at page 6 minute, which has already been decided, which is yet to be restored. We will restore it. This is what has been explained in para 4. So out of the total extent of 2 lakh millet, the minimal number millet, that is only 2,909 acres millet, is pending millet for restoration. That is also on account of millet pendency of the cases.
So, Mr. Substantially done,
Yes, my lord, substantially done, my lord.
and we will issue direction to hand over this possession.
Expedite millet the restoration of this 4,467.
Ah.
And also to take steps to see that the cases are disposed of at earliest.
And apart from that, this possession of this thing cases, no?
4,467.
4,000.
We will do it because the cases have been disposed.
Within how much time?
But your lordship would fix 3 months time.
Right.
My lords, and there shall be a further direction, my lords, if I may say so, my lords, subject to your lordship's convenience. No, time to time when it is being detected. Time to time it is being detected and cases are filed. There shall not be further alienation of tribal lands in favor of. There is a complete prohibition. There is a complete prohibition.
Prohibition, right?
This is minute of 2007 writ petition. Though there is just such provision, my lords, the registration authority for the land.
This is difficult, right? Blanket this sort. Yes. Yes. Mark the presence. The petitioner was elected as MLA from Metapalli Huh? 40.
Item number 40, I am appearing. Item number 40, it will, the cause of action does not survive. Cause of action does not survive.
40. Learned counsel for the petitioner fairly submits.
Since Milad, at the time of laying the pipeline, Milad, the petitions were filed. Now, Milad, since these matters were tagged with the party, now they, Milad, they reported Milad party. Milad, does not.
No, that means he said that you argue your case, why to bank upon him?
But in fact, that petition, Milad, they challenge the very acts itself, Milad.
Item 40, they have challenged to act. Item 40 only act was done. With respect to other, only prayer is not threatening to lay gas pipeline. Threatening to laying gas pipeline without paying compensation.
So it has been laid down.
That is the reason I need to get the
Compensation already paid.
Only 8 matters, Milad, first time listed, Milad.
No, not first time. It has been listed before.
The first time, Milad, after finally ring, Milad, is the first time.
First time.
After 2010, Milad, is first time it is.
First time. So you seek instructions will continue in the list. No. You find out today itself. We have modern means of communication. Find out. If it becomes inevitable, then we will see.
1 week, Milad, Lodge may kindly accommodate for 1 week, Milad. I will not seek further adjournment. I will report it. Kindly, Milad. If the cause surveys, Milad, I will proceed with the matter. Otherwise, Milad, I will report.
He says no. Mr. Praveen Kumar says compensation has been paid.
Lodge may kindly accommodate for 1 week, Milad. I will not seek further.
Right, 41. Now 41 to been paid compensation. He also says.
We produce the copy.
All right.
Okay, should be said.
Don't see us.
Oh, no.
That I am for the appellant. That it's appeal preferred by the water board. That the subsequent, what is under challenge by the petitioner is at page 58. It is a board proceeding. That was issued on 14/12/2006. Page 58. Page 58. This is on 14/12/2006. This board proceeding was issued. Enhancing the water cess. At page 60, if your lordship would see, the earlier policy was the petitioners are the multi-story building owners. They are residing in flats in the apartments. Earlier, the policy was that for individual dwellings, 90 rupees was the minimum charges that were collected. By this impugned proceeding by the petitioners, it has been applied that prior to this proceeding, the MSBs, multi-storied building, only one minimum charge, that is 90 rupees, was being levied. By this impugned proceeding, it has been stated that each flat owner has to pay 90 rupees, treating it as an individual dwelling. They are aggrieved by this particular charges. Their contention is that either you are collecting only 90 rupees, treating the entire MSB as one dwelling unit. Now you are charging 90 rupees for each flat, therefore it is arbitrary and illegal. The learned judge has allowed the petition.
Where is it? You were referring to page 60. Where is it?
Yes, page 58. It begins with page 60. Monthly minimum charges towards bottom. I am reading the heading. Monthly minimum charges for categories 1 and 2 above. Kindly see 90 rupees individual domestic house. B, 90 rupees. In the case of customers under category 1, where complex consists of 5 or more residential apartments as indicated in the plan approved, 90 rupees for flat month. This is their grievance. Either to it was only 90 rupees for the entire building, entire apartment. This is under challenge. Learned single judge has allowed the writ petition. Kindly see at page 41. Because there is a change in the policy, that is the reason I am not troubling your lordships reading the entire judgment. Page 41. For the reasons aforementioned, I hold that the classification of flats in MSBs along with the individual residential houses and the levy of uniform minimum charges on them is arbitrary and unreasonable. I further hold that denying the MSBs the option of entering into agreements where consumption is less than 500 KL month is irrational, arbitrary and invalid. The board is left free to reformulate its tariff policy, and till then it shall follow the same method as was being followed prior to commencing into force of the impugned notification in case of MSBs to the extent of levy and collection of minimum charges. The excess collection of minimum charges, if any, made from the petitioner shall be adjusted in future bills. I further hold that the board shall collect sewer cess on the actual water supply and not on the minimum charges. If any excess charges are recovered towards sewerage charges, they shall be adjusted in future bill. The petition is accordingly disposed of. The board was given liberty to amend the policy. After this writ petition was disposed of, there was a subsequent policy in 2011. The petitioners are not aggrieved by that 2011. They have continuously paying the charges. And in the year 2020, the government has come up with a policy to supply the water free of cost. Not even this 90 rupees. They have the petitioners. Here, your lordship, kindly see, there are 6 petitioners. 6 petitioners have opted for free water supply and they are being supplied the water. Therefore, my respectful submission is the learned single judge when gave the liberty to formulate a new policy. The policy has come into force from 2011 itself. 2011 when it was amended to 115 rupees,
instead of 90, they were not felt aggrieved. They started paying, but they have been continuously paying till 2020. And in 2020, when
Therefore, the meeting survives.
but only to the extent, only to the extent that if the only 5 petitioners, but this is not an order in rem. Only 5 petitioners, if they have paid, that we have to adjust. If they have not paid, we have to collect only 90 rupees, treating it as a dwelling unit, only single dwelling. On merits, I have a good case because your lordships are aware that the proportionality of the service, your lordships are aware what exactly the fee and the tax. Here, what we are collecting is only fee. The learned judge having held that the power of the court under
No, is it necessary for us to examine?
that's the reason I am not taking your lordships to, because there are only 5 petitioners. This order was not in rem. And if they have paid, we will adjust. If they have not paid, we will collect only 90 rupees, treating it as a single dwelling unit.
That we will only say that you take action, whatever.
Your lordship may say that since now there are 2 subsequent policies and the petitioners have opted for free supply of water, your lordship may dispose of the writ appeal accordingly.
Yes. This intra-court appeal is filed
Action was only to dispose of the representation. Very innocuous order. Single agent order is very innocuous. Dispose of representation.
So still petitioner is aggrieved. No, what? Respondent. Which page?
Page 7 note the single agent order. Page 8. Having regard to the facts and circumstances. Second respondent is right. Consider and dispose of the representation. In accordance with law.
Who are the appellants? Third parties.
Yes.
You must have decided by now.
Stay. Stay.
They will also be heard. Then for the appellant mark his presence. This
Then council expired.
notice was issued, no. No, mark is presence, it is stated at
It's not correct.
which, Madam C, what is that 53? Who is it?
1 to 4, yeah?
Huh?
Respondents 52.
1 to 4?
Yes, no, private.
The notice be issued to whom?
2 to 4, Milord. 1 is appeal.
2 to 4.
Yes.
2 to 4. Instead of 32, you write 2 to 4.
Item 54, PV number, it's for social welfare.
Matter arises under AP Scheduled Area Land Transfer Regulation. Treating a transfer of immovable property have taken place contrary to Section 3 of Regulation 1 of 1970. Regulation 1 of 1970 provides that if any transfer of immovable property, that is land, taken place after the cutoff date, that is 3/2/1970, such transfers are void. By that, the authorities constituted under the enactment can pass an order of ejection. That is Section 3 provides. In the instant case, based upon the report of an officer in the Tahsildar office, an LTR case was registered based on a presumption that transfer has taken place prior to the cutoff date between non-tribes. But there is a total prohibition for transfer of immovable property between non-tribes after 3/2/1970. Earlier transfers are not at all affected by the regulation. That is very expressly that they have stated. But though in the instant case, the transfers have taken place prior to the cutoff date, 3/2/1970, the lower court had initiated LTR case and passed an order of ejection. Against that, I filed an appeal before the agent, additional agent to the government. That is also provided under statute. There also, the lower court order was confirmed. Against that, I filed writ petition before this court. And the learned single judge also dismissed the writ petition. Against that, this writ appeal has now preferred. 2 points I raised before all the authorities. One is that the alleged transfer which is said against me is prior to the cutoff date, that is in the year 1968. Cutoff date is 3/2/1970. A full bench has an occasion to consider
3/2/1970.
3/2/1970. A full bench got an occasion to consider the issue whether this regulation is retrospective effect or only from the date on which this regulation came into force.
Prospective.
The full bench 1982 AP, page 1.
AIR.
ALT.
AIR 83.
AIR.
AIR 83.
82 AP, page 1. Declared the law, if a transfer have taken place prior to the cutoff date, the authorities constituted under this enactment have no jurisdiction to entertain any cases. If there is any problem in such transfers, the competent authorities are the different forum, but not this forum. That law has become final. I relied upon that judgment. And I also made a statement, that I produced Pahani copies to say that my name is there prior to this cutoff date in the revenue records. But it is only on the presumption or allegation that my name was found in a different ink in the Pahani record. That was taken or presumed, I got this property after the cutoff date, ignoring my Sada sale date. But these two legal issues I raised before this lower court. But even if I got a property prior to the cutoff date under Sada sale deed, but this court already taken a decision. In such type of cases also, the authorities have
We'll continue after the break. Yes, Mr.
Your Lordship, the present writ petition is filed as challenging the order dated 26/9/2023, Lordship, which was served on us on 26/10, which is at page 4, Lordships.
What does it say?
Lordships, they have rejected our representation, Lordships, for where the petition was allotted a seat in Mamta Dental College.
Which page is the order?
Page 14, Lordships.
Hmm.
Actually, petition was allotted a seat, Lordships, at Mamta Dental College in first round of counseling where she could not join reporting. So we filed a writ petition, Lordship, this Honorable Court directed to make us a representation. We immediately made a representation. Our representation was rejected on 26/9, Lordship, but they were communicated to us on 26/10. Lordship, now the availability of the seats, Lordship, control that it will be known by 4 o'clock of today evening. So the tomorrow, Lordship, similar matter, Lordship, proceed for tomorrow, item 14.
Find out. Learned Miss so and so prays for short accommodation to enable him to seek instructions. Yes.
On three grounds, I am before a Lord's. On 3 grounds, I am before a Lord's. One is that, my Lord, since the transfer of immovable property taking place,
Cut-off date.
Cut-off date 3/2/1970, the orders passed by the lower authorities have no power and jurisdiction to even initiate a case against it, as per full bench judgment. But a 19 AR 1982 AP page 1.
1.
Para 33, subpara 3 below. Para 31, subpara 3 losses, so please just set. This is also the same regulation. Subpara 3. The validity or otherwise of the transfers made prior to section 3(1) or its amendments by regulation so and so cannot be adjudicated upon under section 3(2) of the regulation, and the same has to be challenged in an appropriate forum constituted for deciding the dispute relating to the immovable property situated in agency areas. In the instant case, the transfer have taken place on 10/12/1968. In Telangana area, prior to 1970, all the transfers were taken place under unregistered sale deeds. 95% of the transfers under unregistered sale deeds, it is a common phenomenon here.
All right, that is, let's see what they have to say. Who appears?
One starts up. But this issue, when a transfer has taken place by an unregistered sale deed, when an unregistered sale deed, a transfer has taken place prior to the cut-off date, can an authority still go into that issue is also fallen for consideration before this court, which is reported in 1999, volume 6 ALT, page 174, para 7 and 8 million.
It's covered by full bench. No?
But
para 7 and 8.
if you see the findings of the learned single judge, he has considered 2 issues. One is that your position is not clear prior to 3/2/1970. That was the observation, and you have not filed any document to substantiate your.
All through my defense before all the lower authorities is, I got this property from another non-tribe by virtue of a document dated 10/12/1968 before all the lower authorities. This is my
You
stand.
filed that document. Where is the document? Yours is a Sada sale, right?
Pardon?
Your transaction is a Sada sale.
Yes.
At least the document is not before this court.
I filed it, my lord. Your lordship's primary authority order, 1 second. Primary authority order. 1 second at page 28. Page 28, page 29, last two, page 29, middle miller. He filed the following documents in support of the claim. Page 29, second para, first para, last sentence. He filed the following documents in support of his claim. Certified copy of Pahani's, Xerox copy of simple sale deed dated 10/12/1968, executed by second petitioner in favor of the respondent. This is my consistent plea before all lower authorities in the year Miller 2000.
No, read further. It says only, except the above, respondent did not file any documentary evidence to prove his position over the
Pahani's revenue records I filed Pahani's prior to 1970. Page 29, bottom.
Where is it?
The two documents I placed before lower authorities.
29, the order says there is no documentary evidence.
Page
Go to page 30, second para. Without any valid records.
The record I placed is Sada sale deed and the Pahani record of revenue record I filed.
What is the finding to that effect?
That is my page that there is no finding at all, my lords. Kindly see. Page 29 is the documents I filed. Page 29 bottom is only the consideration. There is nothing.
Where are the Pahanis? Start from which year?
There are 68, 69, 69, 70. That is prior to the cutoff date. It is not. It is the entire record is placed before the lower court. What it had stated is ink is different. My name was shown as enjoyer, but different ink. That's why, my lord, they have not believed that document.
No. The learned judge went ahead stating that there is a concurrent finding. There is a concurrent finding at the court below.
Concurrent filing, my lord, my humble submission is as per the first submission. Once the transfer has taken place, even under a Sada sale deed prior to cutoff date, the authority has no jurisdiction to register or entertain any case as per full bench judgment, para 31, sub para 3. The other contention is even under a unregistered sale deed also, with the transfer taken place prior to the cutoff date, as per the judgment of this court 1999, volume 6 ALT, page 174, just now I passed up. Para 7 and 8. Even in such type of transfers also, the lower courts cannot go into that issue. It is only the civil court are competent to go into the whether the sale is valid or not, whether the civil courts are. That is at page, para 7, I will also please. Para 7 of the judgment, 1999, volume 6 ALT, 174.
So please, everybody has to read.
This is also on the same regulation, but considering full bench. Para 7 is merit, but the learned counsel for contesting respondent and also the counsel for the government contended that the said sale dated 11/3/1963 was not valid for being not registered. As against this contention, the counsel for the petitioner submitted that on the basis of the unregistered sale deed, the petitioner has been in possession on all the right from 1963 and the validity of the sale deed, if any, can be questioned only in a civil court subject to the defense available to the petitioner, and the validity of the sale as such cannot be considered by the authorities constituted under regulations. In support of his contention, he relied upon a full bench judgment of this court in G. Narsareddy versus so and so for immediate reference. Para 31, subpara 3 is a bottom. Just now I brought you lords. Subpara 3 they have relied upon. Ultimately, view of the above judgment of this court, my opinion there is a substance in the argument of the petitioner's counsel. The fact that the sale has taken place in 11/3/1963 is not disputed. In fact, the contesting respondent's father himself had challenged the sale before the competent authority under regulations, but the same was dismissed. That is so, the fact that he has taken place on 11/3/1963 cannot be disputed. As held by the full bench of this court, the validity of the sale or otherwise has to be decided only by the competent court. In other words, if there is any sale which is in contravention of the registration at TTC, it is only for the appropriate court to decide its validity, and no such power are conferred on the authorities under the regulations. The authorities have to simply see whether there are any transfers between the tribals and non-tribals or between tribals and tribals only after commencement of the regulations. And if they are not in accordance with the regulations, then declare such transfers as void in terms of the regulations. Moreover, on verification, I find that the full bench judgment of this court reported in so and so was the very judgment that was under consideration before the Honorable Supreme Court, and the decision relied in Deputy Collector and so and so. The Honorable Supreme Court has confirmed the law laid down by the full bench of this court. Considering all the above judgments, another learned single judge of this court and decision reported in so and so held, regulations and its amendment are prospective, and they do not apply to the transactions prior to the commencement of the regulations. In this view of the matter, I cannot accede to the contention of the counsel for the respondents that the said sale is not for being registered was not valid. Therefore, the same could be set aside by the authorities. But in my considered view, as long as the said sale is prior to the commencement of the regulations, the authorities have no jurisdiction to consider the sale as offending regulations.
Let's hear what he says.
Para 15 is the last. Para 15 alerts. From the above facts, it is clear that the sale deed in person is dated 15/3/1962 and prior to the commencement of regulations in Telangana area, which came into force 1/12/1963. And as per the law that I have noted above, the authorities have no power or jurisdiction to deal with the sale dated 15/3/1962 under regulations. In this case, the said sale deed is 15/3/1962 is an unregistered sale deed. I have already noticed above full bench of this court held the sale is prior to the commencement of regulations. Its validity or some other grounds like non-registration etc. could not be challenged before the authorities under the regulation, and that is a matter of competent court to do so in an appropriate proceedings. The order of the first authority itself shows that these proceedings were initiated on the basis of the notices served on the vendee and sons. The sale deed is admittedly dated 15/3/1962, and initiating proceedings on the basis of notices is clearly beyond the period of 12 years, and as such, initiation of proceedings after a period of 12 years is unreasonable. But this is following full bench judgment.
Yes. Let's hear what he has to say. Yes, what do you see?
Lordship,
It is prior to cutoff date, right? Then
Lordship, the learned single judge rightly justified saying this. He did not produce any say leads, even in terms of the, even
I say it is not your case that this LD is of not 68 but 78. It is not your case. Full bench, mister. How can you argue contrary to full bench?
Lordship, may I just my satisfaction, section 3, transfer of immovable property by a member of scheduled tribe, agency laws, the burden lies upon the rich appellant unless the contrary is proved. There is a presumption. Whether the object intention of
No, you first read full bench then.
the
Full bench you read 82. AIR 82, Andhra Pradesh, page 1.
Yes, Lord.
Para 31 read. Yes. Read para 31, then we will go. You have the copy.
Yes, Lord.
Para
Transfer
30.
of, Lordship, a transfer of immovable
No,
property.
to sum up our conclusions.
To sum up our conclusion on the question arising of this reference to the field bench are as follows. A transfer of immovable property situated in agency tracts made after the coming into force of the AP Schedule Areas Land Transfer Regulation 1 of 1959 and Amendment Regulation 2 of 1963, Amendment Regulation 1 of 1970, even if made in compliance with the provisions of the Transfer of Property Act, Indian Registration Act, Hyderabad Tenancy and Agricultural Lands Act, any other law applicable thereto is null and void. If it contravenes the provisions of section 3(1) of the regulation 1959, its amending regulation, and under section 3(2) of the said regulation, the authorities mentioned therein can decree ejectment of the person claiming under such transfer and pass order, restoring the lands to the transferors or their successor, or pass orders for disposing of the said property as directed therein. Lordship, the transfer admittedly non-tribe to non-tribe. So therefore, it's a contravention of section 3(1)(a), the statute which speaks very clearly. Lordship, the two also. Yes, Lord. Section 3(1) of the Regulation 1 of 1995, its amendment by Regulation 2 of 1963 and 1 of 1970 have a no retrospective operation and don't affect transfer made prior to the said regulation or its amendments coming into force, and the authorities under section 3(2) of the regulation have no jurisdiction to pass an order in relation to the immovable property covered by such transfers. Lordship, 3(2).
Next.
It's 32. Read 32. Lordship, the validity, but these facts are fit into the section 3(2), Lordship, unless contrary is proved. The presumption is to defeat the object of the 1 of 70 is manipulated. That is a finding of the land receipts as well as the possession coupled with the agreement of Sada sale deed to defeat the object of the 1 of 70. That is a section 3(2) which mandates that. In the interest of
You will read 31(3) paragraph.
I will read it.
You are reading one by one and giving expert comments.
I'm
right?
reading.
So what the provision is quoted in a book, thereafter notes are there, right? So first read it.
Sir,
How can we don't understand, Mr. This field deed is, you understand, right? Sale deed is 9/12/68. Cut-off date for the purposes of Act is 3/2/1970.
Correct, Lord.
This transaction cannot be examined under the provisions of the Act. As per full bench, to us it is very simple.
But the learned,
We don't know.
Learned single judge as well as these two authorities, Lordship, there is a presumption the transaction took place after 70. That is a finding of the concurrent authorities as well as learned single judge.
Where is it? You first read 3 and then tell us where is the finding.
The validity,
that it's after 70.
The validity or otherwise of the transfer made prior to section 3(1) or its amendment by regulation 2 of 1963 or 1 of 1970 coming into force can't be adjudicated upon section 3(2) of the regulation, and the same has to be challenged in appropriate forum constituted for deciding disputes relating to immovable property situated in scheduled areas. Applying Please set conclusion to the facts of the present case. The transfer of so and so lordship have been made prior to the coming into force of the regulation. They don't contravene the provisions of section 3(1). Therefore, the special deputy collector, tribal welfare as district collector, from agent to the state government have no jurisdiction to pass orders under section 3(2) of this said regulation, declaring the said transfers as null and void. Accordingly, the writ petition is allowed, the impugned order is quashed. But in the circumstances of the case. The full lordship, my respectful submission, the full court judgment slightly different to fit into the facts or something different, lordship. That's my respectful submission.
How is it different?
Lordship is claiming under the title, under the Sada sale lead, and one more the receipts, which will not confer the title. That is his ground.
Facts and circumstances of the case are similar. How do you say that is different?
Lordship, the prior to 1970, which he filed arbitrarily, there is a presumption for different things. There is a manipulation.
What are you saying? Manipulation, and that's not raised.
That's an
not the
single
issue
judge
in the
interview.
court. You are arguing that for the first time. What is manipulation?
But
There
the
is no
related,
finding
the learned single judge made it observe, lordship, with a different thing. Which is at page number, lordship. Which is at page number 15, lordship.
Authority under the act.
15, lordship.
Page?
Page 15, lordship, learned single judge order.
1-5.
Yes. The Pahanis are interpolated. This is a to decide the same whether interpolation is incorrect or not, whether the petitioner are really in position prior to regulation 1 of 70. This is a crucial issue, Lord.
Where is the finding of the?
No other document has been filed.
So where is the finding of the first authority and the appellate authority to this extent?
Which is at page number 28, lordship. 29, lordship. Even the certified copies of Pahani 68, 69, 69, 70, 95, 96 and simple sale deed. Well, lordship, my respectful submission which cannot confer the title. It can't be transferable. Even assuming if it is a correct also, he can't get the title through these Pahanis as well as simple sale deed.
The question is not whether he can confer, the title can be conferred. The question is whether authorities can initiate action under section 3 of the act. That is the question.
But the question of act is lordship slightly, the document which was filed is prior to 70 itself suspicious.
Please understand, you are appearing for the state government, right?
Yes.
Not for a private party.
So in the interest of the tribal.
Interest of respondent you are arguing. So argue, but argue properly. Understand and then argue. Don't say anything whatever you feel like. You yourself, you are not realizing what you are saying. First you said that it is after 1970. Then you are saying that it is forced, manipulated. Whose case? Where is the, brother has asked you the question, where is the finding recorded by the authority under the act that this sale deed has been executed after 1970? Just like anything.
Burden lies upon the appellant, lordship. That's how I leave. Burden lies upon the appellant to prove I am in a prior to 1970, there is a transaction. He failed to submit before the.
Where is the finding, mister? That this sale deed is forced and has been executed after cut-off date. You said so. And we are asking you, you are saying burden of proof lies. No such finding.
This is, there is a finding, lordship, which is at page number 29. Subsequently, in last paragraph, column number 16 with a different thing and different writing. Except the above, the respondent did not file any documentary evidence to prove his position over the sued land prior to 1 of 70.
This position is completely. No, my question is not a provision. This thing is salaried and been executed, that is before 17. That is not in this, not in this. Like, how can you be non-suited on?
You have nowhere disputed the sale deed. That is not in dispute. It was executed prior to the cutoff date. No such finding to that effect.
But wow.
In fact, these certified copies have been issued by your officers. What you're saying now, if at all any such manipulation, it has been done by your officers. That is the finding here. That's all.
That's all. I'll leave it.
This intra-court appeal is filed against the other past by the single judge.
Yes. Yes.
And the appellants, your lordship. Now, after arguments are over and after this is being done, your lordship, now they have filed an amendment petition to amend the prayer in the writ petition. This writ appeal is filed against the orders and writ petition, your lordship. Now they have filed this petition to amend the date.
You want to file a counter?
I filed a counter.
You have filed?
Yes.
Yes, what is it about?
They have, they wanted to question the impugned order dated 3/3/2006, your lordship, but they have mentioned the notice dated 9/5/2006 in the writ prayer. That was taken into consideration when the order was passed by this honorable court, your lordship, on 29/3/2023, after hearing the case. Now they have filed this amendment petition. In that amendment petition, your lordship, technically it is liable to be dismissed. In fact, it ought not to have been even numbered. This is filed by respondents 4 and 5 together. And fifth respondent is represented by Ali Faruqi, your lordship. And this fourth respondent is represented by my brother, then senior counsel Sri Raghuram. So, without holding a wakalat for the fourth respondent, this petition has been filed together by fourth and fifth respondents. Ali Faruqi does not hold wakalat for the fourth respondent, who is a developer. And the fifth respondent is a legal representative of the owner, claiming
It's
who is
only a change of date. The amendment, it's only a change of date.
That's what I'm saying, your lordship. Change of date.
To the memos, maybe we
Change
have
of
filed the
date.
right memo.
I'll show in the impugned order, your lordship. Change of date has questioned the notices. Proceedings are one and the same. Notice is 9/5/2005 and impugned order date is 3/3/2006. It altogether changes. Now they claim it's a typographical error, and in the body they have mentioned about 3/3/2006. That cannot even be taken into consideration after 17 years of filing of the writ petition, your lordship. And this technically, this petition is liable to be dismissed. As I said, your lordship, the fifth council does not hold wakalat for the fourth respondent.
That's all.
That's it.
Huh?
They have never questioned the impugned order. That's what it's saying in the writ petition. Impugned order is
This is final hearing of a case. It's not a motion hearing. We have not read the file. You have not told us what are the facts. Nothing.
last. Your lordship may kindly see the order of this court, your lordship, in 29/3/2023.
All right, then give us some time. We will go through the facts and find out.
No.
You don't want to argue what can be done. We will have to write an order, right? We cannot say that.
See the matter, your lordship.
You are not arguing, madam. We are telling you what are the facts. You are saying 17 years and all this all.
No, because last occasion, your lordship, they gave us the amendment petition. I just wanted to file a counter for that. I filed a counter and I am arguing only the amendment petition. And that's all. It appeal if I'll, as the time is there, I'll take it, your lordship may take it up tomorrow. I'll act
Yes.
along with the amendment petition.
Yes, tomorrow.
My Lords, the Honorable Chief Justice, Shri Alok Aradhe, my Lord, the Honorable Judges, former Judges of the Honorable High Court, the Chairman of the Bar Council, Member Bar Council of India, the Additional Solicitor General of India, the Deputy Solicitor General of India, the Additional Advocate General, the Public Prosecutor, the President, Telangana High Court Advocates Association, the Registrars, the Director Judicial Academy, the Law Secretary, Telangana State Legal Services Authority, the law officers and other officers, respected senior members of the bar and junior advocates, friends and family members of Sri Justice Munnuru Lakshman and Srimati Justice Gunnu Anupama Chakravarti. Ladies and gentlemen, we have assembled before the full court today to bid farewell to Honorable Sri Justice Munnuru Lakshman and Honorable Srimati Justice Gunnu Anupama Chakravarti, beloved judges of our High Court for the state of Telangana, on the transfer to Rajasthan High Court and Patna High Court respectively. Justice Sri M. Lakshman was born at Velchal village, Rangareddy district, to Sri M. Adivaya and Srimati Rukamma. His Lordship did his primary school education in Velchal Primary School, upper primary education in ZPHS Kohir, intermediate in SAP College, Vikarabad, and Government Junior College, Tandur. His Lordship graduated with BSc from PG College of Science, Saifabad, and with LLB from Usmania University College, Hyderabad. His Lordship pursued his LLM from PG College of Usmania University, Hyderabad. His Lordship enrolled as an advocate in the year 1991 in the Bar Council of AP and actively practiced in civil and criminal and all other branches of law and appeared before all the courts in Hyderabad and Rangareddy district, including revenue authorities. His Lordship was appointed as a district judge in the year 2008 and worked as district judge of Mahbubnagar, Nizamabad and Hyderabad districts. His Lordship worked as principal district judge of Warangal and Khammam districts and as the presiding officer of Labour Court, Hyderabad. His Lordship was elevated as Judge of High Court for the state of Telangana on 15th October 2021. It is fitting to refer to some of the notable judgments rendered by His Lordship as Judge of this court that speaks of His Lordship's great legal acumen. In Sunkam Shankaraya versus State of AP, Criminal RC 1204 of 2009 and batch, an interesting question arose before His Lordships, that is with regard to the non-speaking docket orders in certain criminal revision cases, either allowing them or dismissing them, but with no clear reasons for the same, passed by a former judge of the court who expired due to ailment. Therefore, the said cases were placed before His Lordships for appropriate orders to be passed. The preliminary questions that fell for consideration before His Lordships were that whether the orders which are passed by docket proceedings constituted valid final orders or judgments in a general sense. If not so, what is the resultant effect of such orders? If such orders are found to be a nullity, whether the court can exercise power to either recall or review in the absence of any statutory provision expressly conferring such a power on this court. More so in the light of the provision contained under section 362 of the Criminal Procedure Code. His Lordships, on due consideration of sections 353, 354, 387 of the Code, held that it is the cardinal principle of law that in every judgment or final order, the basic requirements are the facts in dispute, points for determination, and the decision of the court on such points or issues, and the reasons for such a decision. Judgment or a final order has to be pronounced by delivering the whole of the judgment or by reading out the operative portion of the judgment. The first mode of delivery of whole of the judgment arises in a situation where in an open court the judgment or final order in the presence of parties or their counsel is dictated, and the second and third mode arise where the court reserves the judgment and after the judgment is dictated and typed, such a judgment is pronounced in the open court by reading out the whole of the judgment or reading out only the operative portion of the judgment. After such pronouncement, each page of such judgment has to be signed. From the above said procedure, what is indicated is that the judgment final orders must contain not only the resultant portion but also must contain all the requirements of a final order judgment, including reasons. In the present case, such essential aspects are absent, and further any final order of judgment devoid of reasons is a nullity. Therefore, complete absence of reasons in the docket orders were held to be null and void by his lordships. Further, with regard to the court's power to recall or review such orders under the CRPC, his lordships, after examining sections 362, 482 and 369 and relying upon the ratio laid down by the apex court in the landmark judgment of Grindlays Bank Limited, with regard to expression, review, and the distinction made between procedural review and substantive review, and such distinction which was made in civil cases being accepted in criminal cases by the apex court in Ganesh Patel versus Umakant Rajoria's case, held that every court or tribunal exercising criminal jurisdiction has a power to review with regard to procedural lapses which are of such serious nature as to tantamount to nullity, and no court, including the High Court, while exercising criminal jurisdiction, has an inherent power to review orders on merits once judgment has been pronounced and signed. In the light of the above findings, the docket orders either allowing or dismissing the revisions passed by this court on various dates were recalled and restored to the files by his lordships. In Andhra Pradesh Industrial Infrastructure Company Limited versus A.K. Sagar and others, AS number 987 of 1993, in which I had the occasion to appear before his lordships. An appeal was filed assailing the judgment and decree in OS 47 of 1982, whereby the suit filed by the respondent therein for specific performance of contract was decreed. Brief facts of the case are that the original plaintiff made an application to the defendant to allot land about 120 acres in industrial development area and paid rupees 5,000 towards initial deposit, and the defendant issued order allotting land to an extent of 120 acres on an outright sale basis at a provisional rate of 4,600 per acre. The said allotment order contained other terms and conditions. Plaintiff also paid an amount of rupees 5,000 towards acre 95 land, which was reserved for raw material and situated adjacent to the land to an extent of acre 25 umtas, which was already allotted and possession was delivered under execution of agreement of sale in terms of allotment letter. Defendant cancelled the allotment of acre 95. Plaintiff addressed letter requesting the defendant to reconsider the cancellation order. As there was no response from the defendant, the suit was filed and the court granted a decree of specific performance to the respondents therein, directing the appellant complete allotment of the land. His lordships allowed the appeal, holding that there was no enforceable contract of sale for the entire extent of land and that the respondent had not showed his willingness to perform his part of the contract, in the absence of which a decree for specific performance could not have been granted by the court. His lordship further held that the assignment of interest by the original allottee company, which was renamed later in favor of the respondent herein, who was the plaintiff subsequently, is not valid, since originally the suit was filed by the original allottee company and was substituted with the respondent in the appeal by virtue of order passed in an interlocutory application filed by the respondent under Order 6, Rule 17 of the CPC. His lordship observed that GPA creates only an agency and the holder of GPA is the agent of principal. In the present case, since the principal himself was sought to be substituted with the agent, which is a procedure unknown to law, and the basic requirement not being considered by the court below, held that the respondent could have continued the suit proceedings being the representative of the original plaintiff only if there is a valid assignment of interest held by the plaintiff during the pendency of the suit proceedings, and such assignment must be permissible under contract entered between the original plaintiff and the defendant. Keeping in mind that there is a condition in the agreement which clearly prohibits any assignment and subletting, the plaintiff cannot ignore such a written contract and create a new assignment by whatsoever means. Therefore, the respondent was held to be not competent to prosecute the present litigation on account of provision of assignment in the contract, and the appeal was allowed accordingly. In Special Deputy Collector and Land Acquisition Officer, SRSP LA Unit Warangal versus Myakala Veera Reddy and others, the main question before the division bench was whether the reference court could have granted statutory benefits from the date of taking possession of the lands, as the possession of lands in the present case was taken under notification that had lapsed anterior to the date of subsequent valid notification. His Lordship, speaking for the bench, held that the commencement of benefits under section 23(1)(a) is from the date of issuance of preliminary notification, and the terminal point is either date of award or the taking possession of the land, whichever is earlier. Since the possession is under invalid notification, the terminal point to be taken is the date of the award. Therefore, the respondents are entitled for the benefits under section 23(1)(a) of the Act from the date of subsequent notifications to the date of award. Since the possession was taken invoking urgency clause, and a valid possession under section 17 of the Act invoking urgency clause or under section 16 of the Act can only be taken after passing of the award, any possession under invalid notification is not valid possession under the Act. Therefore, the statutory benefits of the Act are not extendable for the said period of invalid possession held by the government. His Lordship further held that the landowners are entitled for rent or damages toward use and occupation for the period the government took possession until the date of passing of award. Honorable Srimati Justice Gunnu Anupama Chakravarti is born to Dr. N. Krishna Chandra Rao and Srimati Mahalakshmi on 21st March 1970 at Palakunda village of Srikakulam district. Her Lordships completed 5 years law course from NBM Law College, Visakhapatnam. Her Lordship is married to Sri G. Lakshman Rao and blessed with a son, Abhishek Rutvik, who is a practicing advocate. His Lordship commenced her practice in the erstwhile High Court of Andhra Pradesh after her enrollment in the year 1994. Her Lordship started working in the office of a senior advocate, Sri T. Niranjan Reddy, and dealt with cases relating to civil, criminal, writ jurisdiction in the High Court, and also attended civil criminal courts apart from cooperative and other tribunals. Her Lordship was appointed as Assistant Government Pleader in the year 2006 and worked as such till 2008. Her Lordships, after pursuing her Masters in Law, was selected as District Judge under direct recruitment and joined the service as Additional District Judge on 2nd November 2008. Her Lordships worked at various places in the erstwhile state of Andhra Pradesh as Judicial Officer. Her Lordships worked as Principal District Judge Karimnagar from January 2019 to September 2020, as Member Secretary, Telangana State Legal Services Authority at Hyderabad till August 2021, as Registrar General of High Court for a brief period, as Chairperson of Cooperative Tribunal Hyderabad, and as the Chairperson of Telangana State VAT Tribunal, Hyderabad in the unified state of Andhra Pradesh. Her Lordship also delivered guest lectures in Judicial Academy Secunderabad and in Nalsar University of Law, Hyderabad. Her Lordship was elevated to the bench and sworn in as Judge of High Court for the state of Telangana on 24th March 2022. It is apt to refer to few judgments rendered by Her Lordships on the occasion that speak to Her Lordship's legal aptitude and remarkable adjudicatory abilities. In Kancharana Sri Priya versus State of Telangana, criminal petition number 5588 of 2023, a petition was filed by an accused who was raised and accused number 4 to quash the docket order passed by the 3rd Additional Junior Civil Judge cum 10th Additional Metropolitan Magistrate at Medchal, Malkajgiri district. The respondent had filed a complaint accusing her husband and her parents and the petitioner herein, who is cousin of husband, of committing offences under Section 498 of IPC and Section 3 and 4 of Dowry Prohibition Act 1961. The contention of the petitioner was that though the case was registered against 4 accused, who were the husband of the respondent, her in-laws and cousin sister of husband of respondent, the police have investigated and filed charge sheet only against accused numbers 1 to 3 by deleting the name of accused number 4. Though police after due investigation have filed charge sheet only against accused 1 to 3, as per the docket order passed by the trial court, cognizance was taken against accused 1 to 4 basing on sworn statements of LW 1 to 3. On the other hand, Lend Assistant Public Prosecutor contended that basing on the sworn statement of the witnesses, the trial court has taken cognizance against accused 1 to 4, though charge sheet is not filed against petitioner accused number 4. Therefore, prayed to dismiss the criminal petition. Her Lordship, while dealing with the case, made a detailed reference to the provisions of CRPC and expostulated the distinct procedures set out in the court in case of warrant cases and in private complaint. On such a thorough examination of the procedure envisaged by the court, in the present case, Her Lordship held that since the record does not reveal that a protest petition was filed by respondent number 2 de facto complainant, and since in a warrant case the question of recording sworn statement will not arise and it will only arise in a private complaint, the trial court could not have equated the procedure for private complaint under section 200 CRPC with that of the warrant case. Thus, if at all, de facto complainant is aggrieved by deletion of the names of the accused, she can file a petition under 319 of CRPC before the concerned court at appropriate stage. Furthermore, so far as involvement of petitioner accused number 4 in the case is concerned, the statements of LW 1 to 3 recorded under section 161 CRPC are inadequate and no allegations are levelled against the petitioner accused number 4. However, the trial court, after considering the sworn statement of witnesses, which are quite contrary to the statements of the witnesses under section 161 of CRPC, with regard to the involvement of accused number 4 in the offence, took cognizance of the case against the petitioner for the offences punishable under section 498A of IPC and section 3 and 4 of Dowry Prohibition Act, which is unjustified. Therefore, Her Lordship set aside the docket order passed by the trial court. In Madinam Raju versus B. Sainath and another, MACMA 267 of 2018, the appellant filed an appeal asking for right compensation as he was aggrieved by the decree given by the Motor Accident Claims Tribunal. According to him, he was entitled to a compensation of rupees 6 lakhs, but to his dismay, the tribunal awarded him an amount of 1,96,000 only. The deceased who passed away in the accident due to the negligence of respondent was the mother of the claimant, who used to earn 15,000 per month by selling vegetables, and since the petitioner was the son of the deceased, was entitled to compensation towards parental consortium. On the other hand, the insurance company argued that the claimant was not entitled to the parental consortium as he no more falls under the definition of child. Her Lordships, after an analysis of the Act and the laws laid down by the Supreme Court in the Magma General Insurance case, held that a parental consortium under the Act is a type of compensation that is awarded to children who lost their parent in a motor vehicle accident, and that is only granted when there occurs a premature death of one of the parents due to an accident. It is compensation given to the child for loss of parental aid, affection, protection, discipline, society, guidance, training, etc. Therefore, Her Lordships held that since in the present case the claimant asking for compensation is a 50-year-old man, and as such he cannot be entitled to compensation under the head of the parental consortium. In Muhammad Umair Mehdi Khan versus State of Telangana, Criminal Revision Case number 279 of 2023, Criminal Revision case was filed seeking to set aside the order of special judge for trial of protection of children from sexual offences Act cases, which confirmed the orders of the magistrate to treat the juvenile accused as adults. Her Lordships, after a thorough examination of the provisions of Juvenile Justice, Care and Protection of Children Model Rules 2016 and the guidelines issued by the Apex Court in Barun Chandra Thakur versus Master Bolu and another 2022 SCC Online SC 870, and exercising the High Court's power under Section 102 of the Juvenile Justice, Care and Protection of Children Act 2015 to call for record of any proceeding which any committee or board or children's court or court passed an order for the purpose of satisfying itself as to the legality or propriety of any such order found that there was a denial of adequate opportunity for the juveniles as the documents were not supplied as per Rule 10(5) of the Juvenile Justice Care and Protection Children Model Rules 2016. Further, Her Lordships observed that the learned magistrate has stated no reasons for differing with the findings of the board member that the children in conflict with law in the present case were unable to understand the legal consequences of their actions. And further, it is evident that within 1 day the entire assessment was done and the learned magistrate without adequate reasons has differed with the board's findings and came to the conclusion that the CCLs are mentally and physically fit and can be prosecuted as adults. Therefore, Her Lordships remanded the matter to the 5th Additional Chief Metropolitan Magistrate cum Principal Magistrate of Juvenile Justice Board for conducting inquiry afresh as contemplated under Rule 10(5) of the Juvenile Justice Care and Protection of Children Model Rules 2016 and for passing orders afresh. The absence of His Lordship Sri Justice M. Lakshman and Her Lordship Srimati Justice G. Anupama Chakravarti will be felt by all of us, but their tenure in this court will remain etched in the minds and hearts of all the members of our legal fraternity forever. I, on behalf of my colleagues, give our best wishes to His Lordship Sri Justice Munnuri Lakshman and Her Lordship Srimati Justice Gunnu Anupama Chakravarti on their transfer to Rajasthan High Court and Patna High Court respectively. And I pray the Almighty to bestow strength and success in all endeavors that may undertake in future. Thank you, my Lord.
My esteemed colleagues on the bench, Mr. B. Narsim Sharma, Additional Solicitor General of India, Mr. B. S. Prasad, Learned Advocate General, Mr. J. Ramchandra Rao, Additional Advocate General, Mr. A. Narasimha Reddy, Chairman, Bar Council of Telangana, Mr. P. Nageswar Rao, President, Telangana High Court Advocates Association, Mr. G. Praveen Kumar, Deputy Solicitor General of India, learned senior advocates, learned members of the bar, registrar and members of staff of the High Court, Director Judicial Academy, representatives from press and media, family members of Brother Justice M. Lakshman and Sister Justice G. Anupama Chakravarti, ladies and gentlemen. We have assembled here to bid a warm and affectionate farewell to our Brother Justice M. Lakshman and Sister Srimati Justice G. Anupama Chakravarti on their transfer to High Court of Rajasthan and High Court of Judicature at Patna, respectively. Mr. Justice M. Lakshman was born on 24 December 1965 at Velchal village of Rangareddy district to late Shri M. Adivaya and late Srimati Rukmamma. He passed his intermediate examination from SAP College, Vikarabad and obtained bachelor's degree in science from PG College of Science, Safabad. Justice M. Lakshman secured LLB degree from Osmania University College, Hyderabad and a master's degree in law from PG College of Osmania, Hyderabad. He was enrolled as an advocate in the year 1991 in the erstwhile Bar Council of Andhra Pradesh and dealt with civil, criminal and other matters in all courts in Hyderabad and Rangareddy district. He was appointed as district and session judge and assumed charge as such on 3rd of November 2008. He served the district judiciary at various places in the state, that is Mehboob, Nizamabad and Hyderabad. Justice M. Lakshman was also posted as principal district judge at Warangal and Khammam districts. He also had the opportunity to serve as presiding officer of Labour Court 1, Hyderabad. Justice M. Lakshman was elected as judge of this court on 15th of October 2021. Justice M. Lakshman, prior to his elevation, served for more than a decade in district judiciary. The rich experience as a judicial officer helped him in performing the duties as judge of this court effectively. He was part of various administrative committees and actively participated in the deliberations of the committees. On the administrative side also, Justice M. Lakshman shouldered the responsibility effectively as an administrative judge of various districts in the state. Justice M. Lakshman during his tenure as a judge of this court decided 2,484 cases, including division bench matters. The law report bear a testimony to his competence and caliber. Mrs. M. Lakshman is happily married to Srimati Madhumati and they are blessed with a daughter Shreya, who is pursuing a master's in US, and a son Akhil, who is a third-year student of law course. I, on my own behalf, as well as on behalf of sister and brother judges, and on behalf of the entire legal fraternity of State of Telangana, bid farewell to Brother Justice M. Lakshman and wish him a successful tenure as judge of Rajasthan High Court. We wish him and his family members peace, prosperity, health, and happiness for years to come. Srimati Justice G. Anupama Chakravarti was born to Dr. M. Krishnachandra Rao and Srimati Mahalakshmi on 21st March 1970 in the erstwhile state of Andhra Pradesh. She obtained her law degree from NBN Law College, Visakhapatnam, and secured her master's degree in law from Nagarjuna University. She started her practice in the chambers of Shri T. Niranjan Reddy, senior advocate, and dealt with writ petitions, civil as well as criminal cases. She was appointed as assistant government pleader in the year 2006 and worked as such till 2008. Justice G. Anupama Chakravarti was appointed as district judge and joined as such on 2nd of November 2008. She served district judiciary in the capacity of additional district judge, principal district judge, and was also posted as member secretary, Telangana State Legal Service Authority, and as Registrar General, High Court for the state of Telangana. Justice G. Anupama Chakravarti had an academic bent of mind and delivered lectures in Judicial Academy as well as Nalsar University of Law, Hyderabad. She was elevated as a judge of this court and took oath on 24th March 2022. Her long experience for more than a decade in the district judiciary has helped her to perform the duties as judge of this court efficiently. She was part of various committees and participated in the deliberations of the committees wholeheartedly. On administrative side also, Justice V. Anupama Chakravarti shouldered the responsibility effectively as an administrative judge of various districts in the state. She, during her tenure as a judge of this court, has decided 4,225 cases, including division bench cases. The law reports bear a testimony to her erudition. Justice G. Anupama Chakravarti is happily married to Shri G. Lakshman Rao and is blessed with a son, Mr. Abhishek Ritvik, a practicing advocate. I, on my behalf as well as on behalf of entire judicial fraternity of State of Telangana, pray and bid a warm and affectionate farewell to Sister Justice G. Anupama Chakravarti and wish her a successful tenure as Judge of High Court of Patna. We wish her and her family members peace, prosperity, health, and happiness in years to come. Thank you.
My hearty pranams to the Honorable Chief Justice, Sri Alok Aradhe Garu, learned brothers and sister judges, Sri B.S. Prasad, learned Advocate General, Sri B. Narasimha Sharma, learned Additional Solicitor General, B. Rajendra Reddy Garu, learned Public Prosecutor, A. Narasimha Reddy Garu, Chairman Bar Council of Telangana, J. Ramchandra Rao, Additional Advocate General, G. Praveen Kumar, Deputy Solicitor General, Alya Nageshwar Rao, President, High Court of High Court Association, Registrars, Director, Judicial Academy, Member Secretary, State Legal Services Authority, Special Government Pleaders, Assistant Government Pleaders, Standing Councils, Law Officers of the State and Central Government, members of the Bar Council of Telangana, members of the legal fraternity, including designated senior advocates, seniors and junior advocates. Joint registrars, deputy registrars, assistant registrars, section officers, and staff of the High Court, my family members, relatives, and friends, ladies and gentlemen, good afternoon to one and all. I feel pleasure and bliss to witness the gathering for bidding farewell to us. I have enrolled in the Bar Council on 30/11/1994. Till the date of my appointment as district judge, I practiced in this High Court and I was with the office of the learned senior counsel Sri T. Niranjan Reddy Garu, where I have learnt work, principles and disciplines. Sri T. Chandrasekhar Reddy Garu, retired district judge, is the father of Mr. T. Niranjan Reddy sir, and is an inspiration for me for becoming a judge. On this platform, I convey my heartfelt thanks to my gurus T. Niranjan Reddy Garu and his father T. Chandrasekhar Reddy Garu. It is a proud moment for me for becoming the judge of this court, as I have started my career from the corridors of this High Court. Today, what I am is because of my family members, especially my parents, husband, son, brothers, and my guru. With their cooperation and support, I am standing before all of you. I thank each and every advocate for their support in smooth discharge of my functions. I tender my apologies if I happen to hurt any one of the advocates during the discharge of my judicial duties. I acknowledge the services rendered by my personal secretaries, court officers, court masters who have attended my court, personal attendants attached to my chambers, drivers, posting clerks, for their unstained cooperation and coordination, rendering in smooth, effective functioning of my office, and the same is highly appreciable. I am also thankful for the staff attached to my residence for making me comfortable with their services, and also for my PSOs for looking after my security. My sincere thanks to the joint registrar buildings, deputy registrar buildings, assistant registrar, posting section, section officers, J Special Administration, and their team members, including the overseer. My special thanks to the protocol staff and for their innumerable services. I also thank the medical staff for their services. I also thank the Special Police Protection Force for the state of Telangana for providing security during my tenure. If I have not mentioned anyone, it is only my inadvertent and not intentional. The loads of memories with me will follow me forever. The love and affection showered by you all means a lot to me and will be cherished throughout my life. I pray the Almighty to shower His choice blessings on you all. Finally, I would say one thing: don't ever chase money. Once you start chasing money, you have to chase till your life end. These words were taught to me by one great personality, Honorable Justice P.S. Mishra, while I was the then advocate, and I should be ever thankful for him. Concludingly, I would say, acquire knowledge. Once you acquire knowledge, money starts chasing you, and it will be till your life end. This would be only my suggestion for the junior advocates of this bar. I once again thanks to each and everyone, and my sincere thanks to my brother judges and to the Honorable Chief Justice, who has kept me in a very comfortable position. Thank you, one and all.
Honorable Chief Justice Alok Arade Garu and B.S. Prasad, and my colleagues on the bench, and Mr. B.S. Prasad, Advocate General, and Narasimha Sharma, Additional Solicitor General, and A. Narasimha Reddy Garu, Bar Council Chairman, Rajendra Reddy, Public Prosecutor, Deputy Solicitor General Praveen, and other senior advocates who are here, and other members of the bar, and registry, all the registrars, the law secretary, as well as the secretary, legal service authority, and my wife Madhumati and my son Akil, who are here, and family members of my colleague Anupama Chakravarti, Mr. Lakshman Rao, other ladies and gentlemen, very good afternoon to you. First of all, I must say, thanks to the Chief Justice as well as the B.S. Prasad, who are kind enough to speak about me, expressing affectionate and pleasing, courteous words on me in assessing my ability to discharge judge of this court. It is a mixed feeling here to live here, a feeling of a new bride leaving parental home And this feeling is not a first marriage feeling, it is a marriage of third or fourth time. Since the reason is, we are experiencing the transfer is not new to us because we came from the district judiciary. We had experience of transfer from one place to other place. And this is one such a transfer, which is an incidence of service jurisprudence. We can't avoid it. It is when we accept the service, we must face to accept the transfer. This is part of it. It is not a new. And it also promotes a unionism because transfer from one state to other states, it brings the bonds between two states. It's an opportunity to go there. And it's also great pleasure while working here among the various reputed seniors who are here. And it is a great opportunity to enhance my abilities, both in civil and criminal and other subjects where I could do the best of my abilities to the satisfaction of all the bar members. I don't say that all the members are satisfied. If all are satisfied, is not a good judge. Only 50% is enough for making a good judge. No, I hope that I secure the 50% of support from the advocates when they visit and said about me words, kind words. This shows that I discharged my duties to the satisfaction of the bar. That feeling I may be leaving from here. Now, I had two opportunities here. As a district judiciary, we have the same batchmates. We are here, we are elevated, we have the good company of it. And as a judge, we elevated from the advocacy. No, we have also good rapport with them because I also practiced here as a sufficient time as an advocate. Though it may not be like a senior and reputed advocate here, I'm a small advocate then. And having the practice from bottom level to all courts, in experience of all laws. And that started my career. In fact, the entry of myself in the judiciary is an accident. I never thought that my pursuing law is not to join any profession. In fact, it is a step in the university to have this shelter to prepare the competitive examinations. Ultimately, I tasted the practice fruits. Then I started ignoring the employment efforts. No, I started practice here initially with criminal practice with V. Kishan. Later, I shifted to HIGHCOURT with Vijay Kumar Devineni. It is occasion to learn many things from them. And it's a great thing to practice here because of various dimensions of law. I could acquire better skills. And my entry in the judiciary is also accident. I never intentionally prepared for getting into service. It is lucky enough that I had law is one of the options in my competitive examinations. That subject has given fetching for me into entry into the judicial service. These are all my short experience in initial days. I'm still in the dilemma to continue the profession or to discard. Ultimately, we continued, and if you turn back, I'm seeing that we really very fortunate to have occupied this kind of position. And it's a great thing for a person like me who hails from a small middle class farmers from a rural village without having any back support of legal or anything. It's a great opportunity. And I hope that I earn all of your affections, and I also had a good company of my colleague judges, and the Chief Justice, who is kind enough to accommodate all things, and he is also compassionate and cordial to each of the members on the bench. And the only victims of transfer is, I told in the afternoon also, my wife is the victim. No, I'm not, I prepared for myself to get anywhere to work. The judge has to work anywhere, a servant like him. She happened to be here only. She's a assistant professor here, and my son is a law final year. And my daughter is recently went to US to pursue her post-graduation. And this is, when I joined this, I thought that I am free from transfer. No, transfer, no, I felt mistake. The transfer is always hangs on the head of the individual who accepted the service. And also I could able to perform my functions effectively, and I greatly indebted to all seniors, eminent who are assisted me in discharge of my duties to enlighten myself in a better position than which I was having when I joined in the service here. And I must say, all members here, one thing to the juniors, one thing, fear suppress the intellectuality. Fearless advocate only he gets a successful lawyer. But don't get fear, and don't think that the judges know everything. Judges is also human being, and you better advocacy leads to better judgments and better disposal. That advocacy you have to inculcate and proceed with. And I must also thanks my staff, particularly personal secretaries, Jagan Reddy and Rahul and Court Master Gafur and other court officer. Probably they must have been experienced my anger also sometimes, and but for them only I could able to dispose civil cases. Fortunately, unfortunately, I was in the civil judge from all cases from my appointment here. A few exceptions is the division bench heading and bails. That is now whatever the subjects which are assigned to me, I could able to discharge to the satisfaction of all the advocates, and I could able to hear. And while I'm the top judge for assignment, because most of them must have been aggrieved by my toughness. That toughness is the only necessity of proper conducting of court management. Because in the old cases, if I don't be tough, very difficult to retain the advocates in my court. Now, except myself, I have to sit and without any advocates, which is impossible to disposal. No, I also apologize for anybody who had, on account of my toughness in the adjournment or in non-granting of adjournments. And all thanks the registry and everyone, particularly protocol and registrar general, other registrars and registrar management, everything, and everyone who cooperated me for successful discharge of my services here. And I enjoyed all the amenities which I could provide. Thank you everyone.